Any mention?
Yes, Mr. Jha.
My lord, I'm placing a mention memo for listing a matter on 21st. my lord.
21st is when? 16. Why? What's the urgency?
My lord,
or non-urgency?
Urgency is there, my lord. My lord, on 31st, the matter is fixed, my lord, where the date of retirement is there, my lord. On the last occasion, on 11th, the matter was came where...
It's fixed on? Next date is when, as per the order sheet?
31st, my lord.
Next date is the 31st?
My lord. Kali will judge.
Please, Your Honor, I beg to mention item number 32. Your Honor, the conducting counsel is out of station. Your Honor.
Mr. Nath.
Yes, Your Honor.
No objection, Your Lordship.
2 weeks as our counsel still to be out of station. Yes.
Obliged.
Wait, please, Your Lordship. I beg to mention item number 25, Your Lordship. Did this matter come after 2 weeks?
25?
Yes, Your Lordship.
Yes, this is it's been adjourned repeatedly.
Mr. SD is out of station.
Who?
Mr. SD is out of station.
So you're there now? Correct.
With some documents also in this matter.
Some documents.
Document is already filed, Lordship. It is there. We have already received the document. It's there. Everything is there.
Anymore. Next, when?
After 2 weeks, Your Lordship.
After 2 weeks, yes.
25 is connected.
Adjournment will sought. Item 24, 25, that means.
Lordship.
24, 25. Due to the unavailability of Mr. SD, who is the respondent counsel item number 25 stop. Now, this matter has been long pending. It's expected next date, no adjournments will be sought.
Lordship.
Much obliged, Your Lordship.
Much Lordship.
Yes.
Main list item number 1.
Your Lordship, I pray that this matter may come up at the end of the board. Mr. Shulai is on legs, Your Lordship. Obliged, Your Lordship.
Supplementary list item number 1.
Lordship, here the petitioner is a contractual government LPT, Sir Lordship.
Sir, is a
contractual government LPT, Sir Lordship, and his contractual harassment was continued till July 19, Lordship. Then thereafter, after that, his harassment was not extended
from
July 19, 2019. Then he approached this honorable court, and this honorable court has given the opportunity to file representation before the respondents. And the respondent has passed an order, respondent number 2, Lordship, and that is at page, Lordship, 22, Lordship, and given direction to the respondent number 4 to extend my contractual harassment, Lordship. Then, Lordship, I was continued, Lordship. Now, Lordship, that is the last page 24, Lordship, they have passed an order, respondent number 4, saying that I am a tainted teacher, so my service has been
you're a tainted teacher in what sense? You appeared for the exams?
I have appeared for the exam, but I was not, though my name was appeared in the selection list, but because the term of the select list was expired, I didn't get
qualified, that means?
Yes, Lordship.
As a tainted teacher?
Yes, I did not get the regular appointment, Lordship. Then after the expiry, then only I got the similar writ petition has been filed, Lordship. One writ petition has been filed by one of the petitioners here, Lordship.
What is the order passed there?
Then, that instruction, Lordship. That is listing coming on 22nd, Lordship. Let this matter maybe.
What's the PC number?
Writ petition number, Lordship.
253 of 2023, Your
Yes,
Lordship.
heard Ms. S.A. Sheikh, the counsel petitioner, issue notice. MSL Elon can be present, accept notice on behalf of the respondents. No forms was called for. Next paragraph submitted that a similar matter being WC number
253 of 2023.
253 of
2023
2023 is due to be listed on 22nd of
of this month, Lordship. Of this month.
August. Just together on next date for instruction.
Highly.
Obliged, Your Lordship.
Item number 2.
Yes, how was this?
My Lordship, I was appointed as a senior technical assistant in the physics department of Northeastern Hill University on 5th July 1986, and I retired on 30th June 2022.
Yes.
And Your Lordship, there is a scheme which is known as modified para 9 modified assured career progression scheme. According to the scheme, I should get three financial benefits after 10 years. First 10 years, then 20 years, then 30 years.
How many years you served? 30 years.
30 years. But I was
Three financial upgradations, you mean?
but-
Three financial upgradations.
yeah, but I was deprived of one financial upgradation. This
When
is
was
my
that?
main grievances, Your Lordship.
When was for which segment? First 10 years, second 10 years, or third 10
The
years?
first one.
For the first one.
Yeah.
So why are you coming now after 20 years then for your first financial upgradation?
No, the first one because when we got the order was issued later, and there was discrimination also. Others were given 3 in the same.
When was that order passed?
The orders. Annexure 4, Your Lordship. Annexure 4, page 25.
But this is 2009, Mr. Datta. 2009.
Yes.
Yes. Then what does it say?
Yes, this is in Annexure 4.
What does it say? Yes. What does it say? Modified assured career progression scheme.
Yes.
Personal company. Yes. What from here? What do you derive? What benefit have you derived from this memorandum?
That is, I'll read in para. That Your Honor, Your Lordship, I was appointed in the scale of 550.
No, from this office memorandum issuing,
Yeah.
what benefit has been bestowed upon
upgraded
you
financial
by this
benefit.
memorandum?
Upgraded financial benefit. That is pay
2009.
upgradation.
So those issued 2009.
Yes.
Why didn't you come to, then what you say for the first 10 years your upgradation is not given, correct?
Yes.
So why you come so late then?
No, I was not aware of this because I was looking for the orders and all the papers, just to ascertain whether I was deprived or
But
whether.
you submitted just now that the other similar situated people already given.
Your Honor, I'll satisfy you because there are many documents which I could not procure from the university.
Yes.
And the resolution of the council, etc., which I got in later dates. I had to file RIT and all these things. So after I collected all the papers, and
After how many years?
So the delay may kindly be condoned, Your
It's
Lordship.
not a
because-
question of condemnation, Billy. You slept over your rights.
Yeah, this is my right. I was not sleeping on my right. I have been submitting my representations to the respondents. There are many representations.
Yes. Who's the pin for Nehu?
Accepted notice, Your Lordship, on behalf of Respondent 3 and 4.
Yes.
On behalf of Respondent 3 and 4, Your Lordship, will obtain instruction, Your Lordship.
I filed many representations. I was waiting for the.
Reparation in 2009 for any right accrued to you. Now we're sitting in 2023. You're coming to assert that right.
I was not sitting, Your Lordship. I have been filing representations.
Yes,
There are 5
Mr.
representations.
Appreciate one more aspect. I'm appearing for UGC.
Yes.
The representations that the Petitioners Council is referring to are dated 2018. From 9 to 18, there are no communications at all.
No, we'll see that. Let him meet the delay. We won't admit this petition also.
There is no ground mentioned in the
Anyway, yes, heard Mr. D.K. Datta, Learned Counsel for the petition issue notice. MS, who's appearing first? Union? MSS from Thao, Vice, Dr. M. Mozika, DGSI, except those we have 1 and 2. Then MSS Shalam is present. We have number 3 and 4. Nehu, UGC is not here. Or number 2. Oh, 1 is from Thao, 2 is P. Agarwal, 3 and 4 is Shalam. Yes, list after 3 weeks for instructions affidavit. Yes. Woke up one fine day and realized that he didn't get his benefits.
No, I have been pursuing the matter, Your Lordship. I was not sleeping.
Main list item number 2.
Lordship, in this matter, respondent is supposed to file affidavits.
Yes.
Lordship, in this matter, respondent is supposed to file affidavit.
Your Lordship, we're praying for some time, Your Lordship.
Why? Why you don't have filed affidavit?
Your Lordship, we've already prepared. However, it's been sent to the department. We are still yet to receive the same.
MS Ruthau, please for further 2 weeks time for affidavit. Just thereafter and so on. So yes.
Much of much.
Yes.
3.
354. Let's see. Okay. Yes.
These are these MTC matters.
Yes, Mr. Sen. What is
we received, insofar as number 3 is concerned, we received their writ petition on the 14th. So there's some delay. We filed our affidavit. We served them a copy this morning.
14 item number?
Item number 3, which my learned senior is appearing in Malcolm Ward.
Yes.
As far as MTC is concerned, they served us a copy of the writ petition on the 14th itself. So we took some time to obtain the instructions. We filed our affidavit both on item number 3 and 4 this morning, and we've served them copies.
Yes.
If they need to file any rejoinder, may I pray this matter may come up next week, Manoj.
Has it come on record, the affidavit?
No, not yet. It's being filed in the course of the day, Manoj.
We also will, I think my friend will give it to
Mr. S. and Learned Counsel for respondent number.
Well, it's in item number 3 is respondent number 3.
Item number 3 submits that the affidavit has been filed. This is matter after 1 week.
On Tuesday, preferably, Manoj, if it's permissible, because will AG be here?
Your next is on Tuesday.
Interim order may continue.
22nd. On 22nd.
Interim order may continue.
Interim order of addition continues.
Okay.
Number 4, same order.
Same order.
In item number 4, I have been served a copy of an affidavit by both by the respondent number 1 and 2, my lords, that is the MTC.
Yeah.
And my lords, the respondent number 3, just now. So I'll file a rejoinder to these affidavits.
We'll listen 22nd.
22nd, my lords. It's 22nd, I'll have a little difficulty, my lords. I'll not be here. I don't want to seek an adjournment of this matter. May I
ask for special date? Mr. Sen asked for 22nd.
Lordship.
My lords, may I pray for the 24th or the 25th, subject to your lordship's kind convenience?
I'm always here. It's up to the council's convenience.
As long as they file the rejoinder and give us a copy beforehand.
My lords.
24th.
24th. Obliged. My lords, the interim order may continue.
Yes, interim order.
Actually, my lords, in my matter, there is no interim order. The AG had made a statement that there would be no coercive action.
Yes, undertaking.
So that will extend.
Undertaking, if any, shall continue.
My lords.
Obliged.
Obliged.
Item number 5.
The JCDC Lordship, they are supposed to file the
Yeah, please, Your Lordship. I pray humbly for another 2 weeks' time, Your Lordship.
2022 matter.
Yes, but we are newly implemented in this matter, Your Lordship.
Newly implemented, but
Newly implemented.
Yes, Your Lordship.
Have we filed affidavit?
State is a foreign party, not
Yes.
State is a foreign party, so not.
What's the matter about?
this is regarding that they have this municipal board and the JCDC. They have occupied my land. I'm yes.
Relocation of the
I filed on basis of my Mr. Council and
They are the main.
Because they said they have constructed a house in my land.
The respondents number 5 and 6 have been implemented on 27/4/2023. I yet to file the affidavit stop. MS Marpana today prays for some more time. Yes, sir. Further 2 weeks is granted. It's expected next date the affidavit will be on board with response 5 and 6.
Much obliged.
Much proceed.
6.
Yes.
Your Honor, I appear for respondent number 3.
Where's the affidavit?
This is the lady, she's senior citizen, so she's having problem to come from her house. So just 1 week may be granted. So she was ill in between and
from her house? She stays in Shillong?
She stays in Mahindraganj.
Then you can get it sworn there by magistrate, by notary.
So she is unable to come. She was not well.
She doesn't need to come to Shillong.
No, there, tell me.
Mr. Paske for respondent number 3. What about the government? Who's going for the state? Kharmi 1 and 2. What's the matter about, Mr. Mehta?
Your Lordship, I submitted a representation, Your Lordship, to the District Council, Your Lordship, under Section 8 of the Meghalaya Land Transfer Act, but they did not do anything, Your Lordship.
Oh, that matter is further 2 weeks. No one for the state, no one appears respondents 1 and 2. Mr. Paske on behalf of respondent number 3, please for the further 2 weeks time to file affidavit.
Deeply obliged.
7.
Your Lordship, here also I'm praying for further 2 weeks' time, Your Lordship, to file.
What's the matter of transfer?
NIT.
No, Your Lordship, NIT.
NIT.
The teacher scheme.
Yes, MS from Thao Vice.
Interim order may continue. Your
Praise
Lordship.
for and allow further to stand for adequate interim order passed earlier shall continue until next date.
8.
Much obliged.
May I please, Your Lordship? This matters also I am praying for 2 weeks' time, Your Lordship.
This is becoming a disease. Just asking for time from GGDC.
We'll file this, Your Lordship, on the next day.
If it is not filed like this court observed earlier, just call for the records officer concerned. We'll see from the records. Counsel also won't be necessary. We'll just look from the records and pass orders. If that's the case, then we'll have to resort to that. Otherwise, how many times have you sought to file affidavit? How many times? It's been filed since
from November, March.
This was filed since April
2002.
When?
Since March.
Oh, this year. Okay. Further 2 weeks time as per granted to MS Marpana on behalf of respondents number
1, 2 and 3.
1,
1, 2 and 3.
file affidavit.
9.
Much obliged.
Do not shoot in a ballet. Not like that. No, I'm sure.
Lordship, we were supposed to file rejoinder, Lordship, in this.
Yes, Mr. Chanda.
Lordship,
Why you're not
however, I'm
rejoinder?
praying for 2 weeks, Lordship, time. We are
3
in the
weeks time
process.
for rejoinder?
2 weeks, Lordship.
No objection.
Mr. Chanda, please for allowed further 2 weeks time to file rejoinder affidavit is list thereafter also.
10.
May I please, Your Lordship? Your Lordship, I'm praying for some more time, Your Lordship. We have not received complete instructions in this matter, Your Lordship.
Further 2 weeks time granted to the state respondents for affidavit list thereafter also. As prayed, further week time to this.
Obliged, Lordship.
11.
Hey, please, Lordship. Lordship, I pray for some more time, Lordship. I have not received instructions in this matter yet.
It's a fresh matter. Yes, Mr. H. Karonna, please for allowed 3 weeks time to file affidavits. Yes.
Much obliged.
12.
May I please, Your Lordship?
Same order.
Lordship, I bring to my Lord's notice that this instant matter has become infructuous. The prayer made in this petition has been obliged, Lordship.
Let's see.
Complied to. I can.
What is the prayer in the petition?
Lordship, the prayer is at page number 9. It states, in the premises aforesaid, it is humbly prayed that Your Lordship may be pleased to admit this petition, call for records, issue rule upon the respondents, upon cause or causes being shown, and upon hearing parties, Lordship may be pleased to direct respondents number 3 and 4 to conduct free, fair, and impartial election of so-and-so VEC under zigzag scenario block, so within a period may be fixed. As Lordship, as per the notification dated 2nd August.
Election will be held on 18th August. Oh no, on 29th. Yes, sir. This added application has been filed seeking directions for the holding of elections to the Tung Rurchar TUNGRURCHER VEC under zigzag ZAK Scene RD block, Southwest Garo Hills, within reasonable time. Now, the next paragraph, the State Counsel, Mr. H. Karmalang, Senior Government Advocate now.
What's additional senior?
Additional Senior Government Advocate has produced before this court of notice dated 2nd August 2023, issued by the block liaison officer of the concerned zigzag Scene RD block, South Garo Hills, whereby it has been notified to all the members of Tungrurchar Village Employment Council that the election of women president secretary will be held on 29 August 2023 at the place as indicated in the notice term. A copy of the notice is taken on board and made part of the record and marked as X. Yes. Next part, in view of the notice produced, in view of the notice dated 2nd August, nothing survives for consideration of the petition, and the same is accordingly closed and disposed of. You gave a copy?
13.
Much obliged. Okay. What was the last one?
They have filed it.
Okay, please, Lordship, we filed the affidavit this morning, Lordship.
So you're arguing the matter today?
Lordship, this matter may be taken up 22nd, Lordship, and if any rejoinder,
I'll have to file a reply because I have been served with a copy of this affidavit just now. Your Lordship said directed it be served earlier and I've been given 2 days time to file a reply.
Lordship, there's some difficulties in between, Lordship.
Okay, we'll give you Independence Day bonus.
Oblige, Lordship.
Affidavit on behalf of the respondent number.
Petitioners. For petitioners, Lordship. Petitioners.
Additional affidavit on behalf of the petitioner has been filed today itself. Stop Mr. K. Paul's counsel seeks time to file the joinder to the same. Stop this on 22nd as prayed.
24th.
24th.
Oblige.
Highly obliged.
14.
Lordship, 13 to 22 are connected matters.
All connected matters. 13 to 22.
13 to 22, Lordship.
Second call. Item number 1.
Much obliged.
Yes.
This is your Lordship. Lordship, there is submission made on the first day of the
Where is
motion.
that MSS Marpanash is here just now?
Where is another set of?
Yes, continue.
No. That the issue involved in WPC number 466 of 2021 and with the present petition is not connected. That is absolutely incorrect, Your Lordship.
Let us see.
If Lordship is pleased.
It's not a declaration of results.
Yes, Your Lordship, because there was a stay order passed in WPC number 466 of 2021.
Where's that order?
Lordship, that has been enclosed on page. Lordship, kindly bear with me. This is the order dated 17/12.
Aye.
17/12.
Page 67.
Huh?
67.
Lordship, the writ petition, it has been annexed at Annexure 7 at page 67, Your Lordship. Page 67 to the...
This order has been annexed?
Lordship, yes. At page 67, Your Lordship.
Here, Mr. Philemon Nomri is appearing for the petitioner. What's the status of this case now?
Lordship is pending because some of the petitioner, Lordship, they file as SLP before the Honorable Supreme Court, Lordship. So it has been... Yes. So, some of the writ petitioner in those proceeding, Lordship, they have preferred SLP before the Honorable
against this order?
No, against the order passed by the division bench, Lordship.
This order went before the division bench?
Lordship, yes. Lordship, kindly come to...
Page 68.
Lordship will kindly come to page 68.
Of the writ petition?
Lordship, yes. Again, this judgment, Your Lordship. Page 68, Your Lordship.
Yes.
So against this, some of the writ, the writ petitioner, Your Lordship. I mean the writ petitioner and the private respondent.
I can't take it up. This is regarding that.
Lordship, yes.
That's why we went before the other bench.
Lordship, in fact, I have no grievance, Your Lordship, because the simple issue, the simple case here, Your Lordship, is regarding the non-declaring of the result, Your Lordship.
Yes, what do you have to say?
Your Lordship, kindly take this matter after 1 week. We have already taken steps, Your Lordship.
Not the question taking steps. Now the question, see, last time you see the last order. See the last order passed by this court on the last occasion. Ms. Nomri, this matter
is pending.
Is this regarding enforcement? But there's another matter you appeared in. This is what is this? Damien Rongrin. 466. Is it connected to this matter?
Connected, yes.
Connected, not that is before the other court. It's disabled before this court. But not this particular matter.
But the present one, Your Lordship, if Lordship kindly come to the prayer made in the writ petition, if Lordship
it was for declaration of results, but then what happened to declaration of result? It was stopped because of the
yes, because of his writ petition.
Then what happened after that?
Lordship, the result remain as it kept in abeyance, Your Lordship. If Lordship kindly come to...
Okay, fine. What stage this is? What stage that case 466 now?
Lordship, because of
it is still pending. Yes, Mr. N.D. Shulai today has produced a copy of the order dated 17/12/2021 in WPC number 466/2021. When he submits that is directly in issue with the present matter. So, I perused the order passed as also the order of the division bench passed in the connected matters. Review the matter, list this matter together with 466/21 before the concerned court.
Lord.
You take it back.
Lord. Highly applaud.
Hearing supplementary list item number 3.
Please, Your Lordship.
Resolve.
Yes, Your Lordship.
Yes. Been resolved. Very good.
We're just praying for a time frame, my lord.
Yes. Time frame meaning?
If the matter can be released within 2 months or 3 months, my lord.
State respondent may be directed.
Yes, sir.
3 months.
Yes. The matter which had been sent for mediation has since been returned. This matter was referred to mediation. The office note indicates that the mediation process has been successful and the parties have arrived at a mutual agreement on.
Yes, sir. Date is 12 August 2023.
12 August?
12 August.
On 12 August 2023. Accordingly, this matter is disposed of in terms of the mutual agreement, which is part of the records now. Next, on the prayer of the parties, the state respondents also directed to dispose of or to dispose of the entire matter of settlement of the family pension within a period of 3 months from the date of receipt of this order.
Highly.
Matter stands upon a closed disposal.
Item number 4.
May it please your lordship.
It is also resolved.
No, lordship,
your lordship.
This can go to
settlement
the
could
civil
not
court,
be reached, your
because
lordship.
they are not able to.
Why?
Because the petitioner, sorry, your lordship, the respondent was
they come, lordship.
claiming for the property as well, your lordship.
Yes.
The respondent number 5 was claiming for the property as well, your lordship. So the
See, lordship, the
could not be
property
reached, your
already in the civil court is already we have filed a petition there in the Stura, lordship. This is regarding the family pension only. So let it go through the civil court.
This is only for death certificate, your lordship. Since the succession
Document
certificate
here
is
it
also.
says, seen the report of Secretary High Court Mediation Committee indicating that the referred case not settled. List the matter on for hearing after 2 weeks.
Lordship. First, lordship.
Your pleasure.
Or dispose of now. We dispose of now.
Otherwise, lordship, because they party want to go to the civil
You
court.
ready to argue the matter?
Yes, your lordship.
Yes, Mr. Momin. You should let her argue. Yes.
Your lordship, since the succession certificate is also already in stay, your lordship, it has been
already
in whole, your lordship, on whole.
Okay, let's pump you the order. Pump your whole things, pour out of order. Yes. Let's see your prayer.
Your lordship, my prayer is at page 9, your lordship.
Yes.
May I
What if you fetch the certificate of data in favor of the petition disposal representation dated? See, that certificate has already been issued to Mr. P.T. Sama's client.
Yes, your lordship.
In her name.
Yes, your lordship.
Now you're asking to be issued in your name.
Yes, your
That not be possible. You can be issued a duplicate, but how will it be issued? In one showing that he is the wife. I mean your respondent's a wife and your case
I'm also the legally wedded wife, your lordship.
No, whatever it is, then you have to.
Last occasion, I have produced one order, your lordship, in which the similar situated person, your lordship, your lordship was pleased to pass an order, your lordship, to dispose of the representation, and based on that representation,
How will a poor health authority deprive because disposed of? Because things that you're asking for that certificate to be issued in your name. I mean, showing this thing.
Yes, your lordship.
Yes. And you already got it in your name.
Your lordship, we have got it.
When was it issued to you?
It issued to me on the. This is the certificate on the 26 March 2022.
20?
I have Annex 11, lordship, page 22. 26 03 2022. That means 26 March 2022.
Is it annexed in your written petition?
No,
They
your
don't
lordship.
annex. I have annexed in my affidavit. This
You're number 3.
At page 20.
Which respondent? You're number 5
yes,
or number
yes,
3?
number 5, Your Lordship.
He's number 5.
Yes, Your Lordship.
The thing is that because since for 25 years the disease was with me.
25 days?
25 years. For 25 years. And the petitioner have decided, and at the time of
oh yes, I remember now. Yes, this case.
During the funeral also the petitioner never come.
Yes. You also your marriage also is not.
Both the parties' marriage also
No,
is
Your Lordship.
illegal
My
because
marriage is legal, Your Lordship.
they are
As
also
per
in
the
Assam.
specific marriage act, Your Lordship.
That also is a deed of marriage. There should not be happen. There should be a proper marriage certificate.
Yours is not proper also.
Marriage.
Yes, that I am not denying, Lordship. But then, as per the Christian marriage act, that Episcopal, the person who have the Episcopal ordination, they can receive Episcopal ordination. That they said in the act is there. Yes.
Ordination.
Yes, they can solemnize the marriage, Lordship. There is in the act is there, Lordship.
It's outside the jurisdiction of this honourable court, Your Lordship.
This is
of course
you obtained this one from Jordan.
Jordan, Your Lordship.
Yeah, of
It
course.
wouldn't be recognized in India, Your Lordship.
Not signed by anybody. Who's this also? Anyway, this court not go into this. Wedding sanctuary. Like Las Vegas, no? You don't know.
This one is Lordship.
You know, these also can be downloaded from the net and your name filled in also.
No,
This kind of
Lordship,
certificate.
Actually, this is not downloaded. Of course, actually, it should have been here, but then
You were not legally married to the deceased also. You also were not.
yes,
I was
they are
legally
also
married,
not
Your
legally married. And moreover, they have run away for 25 years. They have decided my house.
We were married, Your Lordship. My marriage
That
certificate.
marriage may be
I've
there,
annexed my
but
marriage
practically they were
certificate,
not
Your Lordship.
living together. In my the certificate or the hospital, I was considered as a wife. I happened there when he was sick in the hospital. I was there. And what prevent them from coming to the hospital just to see? Even during the funeral, she never bothered to come. Even in fact,
funeral also.
yes, never come. His 2 children.
The funeral was held in Tura, Your Lordship.
2 sons have come. 2 sons have come to the visit to the at least, but they are also not supporting her mother. In the title suit, they said that
Deceased was, in fact, visiting the petitioner, Your Lordship, in Tura, Your Lordship.
the disease never stay in
And the
Tura. He
deceased
was in the
The funeral was held in Tura itself, Your
now
Lordship.
also Kenstre Shillong.
Okay.
Kenstre Shillong.
I think you'll have to go to the civil court.
We will go to the civil court, Lordship.
The suit's pending there.
In Tura, we have one suit is pending. That is regarding the property, landed properties.
Can't go into side. We will not go into the veracity of these marriage certificates or whether you are staying or whatever is your claim.
Only coming for the death certificate.
How will the court issue an order that a death certificate issued in
Prosecuted persons were also issued death certificate.
No, that is a different case. Here is a different case.
See, the fact remains that they have already been issued one, correct? Now what you have to establish is your legal wife, and then you have to discredit that death certificate. If you have discredited that by evidence, and then maybe you'll be entitled to whatever the debts or securities or the property that he has.
Then let the death certificate be kept in.
You're asking for the court. This is issued by a competent
Let
authority.
them get the
unless Mr. Moment, unless there are positive findings as to the authentic or whether this can be accepted or not, this court can't pass orders in jurisdiction to say that for a time being that we kept the bench.
Lordship, exactly. And there is
Please,
okay.
it's okay.
I'm sorry, Lordship.
No, because on the basis of this death certificate, my lord, the wife is claiming for other entitlements, my lord.
You have to block that. That's up to you.
So far as succession certificate is concerned, my lord.
Forget succession. You file a suit now. You question the veracity of that.
Person, my lord, already issued a fresh death certificate, my lord.
Which case is this?
On one of the matter.
This is a different one. Not here.
If that can be done, my lord. And moreover, as per the register
show me how it's done.
We have already produced the order, Your Lordship, on last occasion.
Registers Act also, my lord.
And there is
no bar, my lord.
In the instant case,
See, issuance of a duplicate certificate fresh one is no bar, but issuing in the name of 2 different persons.
No, but that has been issued, my lord.
Maybe in inadvertence.
Yes. And moreover, in the petition,
Not only in one case, my lord. In 2-3 cases, my lord, it has been done, my lord.
No, we just said that you let them examine it again. That's all. Not that this court directed for issuing this in your name. There's no such order.
They did issue.
So that is up to them. Maybe they're wrong.
No, but not only in one case, my lord.
Same thing. This is just direction that okay, fine. Your representation is pending before them for issuing in your name and whatever.
On the basis of parity also, my lord, if they can issue for others also. Why not in this case, my lord?
This court has seen your claim and their claim. It has to go by evidence.
I think if I'm not mistaken, my lord, there is one judgment of this honorable court, my lord, wherein death has been issued.
Yeah, that's a duplicate one. I mean, as a register of births and deaths, the judgment is there. Let us see.
Don't have the authority.
And moreover, technically, here they cannot pass any order because they never make a prayer to stay this death certificate.
No, we're not looking into that. It's just that whether you are asking for.
Yes.
You're asking for.
We will go to the civil court.
And he said that 25 years you deserted him.
No,
this is the fact.
This is the fact. They have been coming, my lord, and admittedly, my lord, they will also not disagree. The funeral was held at Tura itself, my lord.
No, we have taken the death.
That order. Let's just matter next week for further hearing.
Hello, Blanche.
Most press lordship.
Venus, item 23.
Mr. Nandi is there, Millets, for the.
He's online?
No, he's not online. I was just trying to see whether he's online.
He came last occasion. He was the same Mr. Ganguly, no?
Mr. Ganguly, Millets. My apologies.
Will this after some time?
End of the board.
Yes.
$26.
Lordship, in this case, we are making a last attempt on a compromise. So, in fact, we're meeting next week, both the parties.
You try to end it, yes?
Yes, we'll try to end it.
Both the senior counsel without the parties submit that her last attempt being made at out of court settlement stopped. Accordingly, with the submission, this is a matter of the 4 weeks. It's to enable settlement talks.
Obrigado.
27.
Yes,
May it please your lordship.
Yes. You make arguments short?
Last time I had said 15 minutes, give or take 5 minutes, my lord.
No, because this matter has been hanging fire for no reason.
Lordship. In fact, having revisited the matter in preparation for today's hearing, at least my personal opinion is it's a very simple matter, my lord. Unnecessarily, both parties complicated matters on the last round of hearing.
Okay.
Today, hopefully, my lord, it won't be that long. Lordship, diving right into the matter, even though some time has passed since the last round of hearing, I'm fairly confident that the Lordship would recall some of the background facts. I'll just spend a few minutes on three main facts. One, my lord, contract was signed. That was sometime in 1995, 17th July 1995. From the contract, my lord, there are only 2 clauses which are relevant, which are important. Those clauses, my lord, will kindly see are at page 40 4 of my CRP.
Page 44.
Page 44 of the CRP, of the revision petition.
Yes, arbitration.
Yes, first relevant clause is that there is an arbitration clause for dispute resolution. Fairly voluminous clause. I will not take Mello through the entire clause. Suffice to point out that arbitration was to be conducted by 3 arbitrators. Panel of 3 arbitrators. Second relevant point in this clause is an absence of seat or venue of arbitration.
Yes.
There is absolute silence on that issue, on that point.
Yes.
Second relevant clause, my lord, is at page 43.
43?
Previous page, my lord, 43. That is clause 58.2. 58.2, my lord, is a jurisdiction clause.
Yes.
With Lordship's permission, I'll just read this clause. The court situated at the place where the headquarters of the corporation is situated, namely Shillong, will have jurisdiction to entertain civil suits pertaining to the contract. So there are 2 aspects that immediately jumps up from this clause. One is that jurisdiction has been granted to Shillong courts.
Civil suits.
The second is civil suits. I'll just come to that. Jurisdiction has been granted. It doesn't mention exclusive jurisdiction. It doesn't mention only Shillong courts, etc. But I submit, and Lordship will be aware of the position of law in this regard, that the absence of words like exclusive, only, alone is not relevant, as long as the intention of the parties to confine jurisdiction to a particular place is evident, which it is here. In my synopsis, my lord, I have pointed out Swastik Gas's case, which Lordship has also applied in other matters, my lord. So, absence of alone, exclusive, not relevant. Exclusive jurisdiction has been granted to Shillong courts, number 1. Number 2, civil suits, to entertain civil suits. So much, naturally, much has been made by the respondents on the fact that it doesn't really say, it confines jurisdiction to civil suits. My response on that aspect is 2 responses. One, this clause has to be read, cannot be read divorced from the agreement. If the agreement has an arbitration clause, my lord, naturally, any proceeding in a civil court would have to be a proceeding arising out of that arbitration. There cannot be a situation, because of the presence of the arbitration clause, there cannot be a situation where a party agitates whatever dispute before a normal civil court under normal civil proceedings if the party attempts, either of the parties attempts that.
Yes.
I had taken Lordship through to Section 8 of the Arbitration Act. Section 8 of the Arbitration Act requires a civil court to refer the parties to arbitration if there is an arbitration clause. So I will not spend much time on this, but the Section 8 is self-evident. If there is an arbitration clause, no party will be in a position to approach a civil court. The other party or the court itself will ensure that they are sent for arbitration. So any proceeding that ultimately comes up in a civil court has to be a proceeding arising out of arbitration. So the word civil suit has to be read in that context.
Yes. Okay.
Number 1. And number 2.
There's a different argument you're making now.
No.
This was argued.
This was
argued, okay. You're saying problem with your throat?
Yes, slightly sore throat. I apologize. Secondly, my lord, about civil suits itself, Lordship on the last occasion had queried as to the genesis of this agreement. I had submitted, frankly, that this is a very old format, my lord. Old format of the agreement. This civil suits, this clause itself relates to the 1940 Act, Arbitration Act.
It was signed when, this agreement?
This was 95, but the format itself relates to or is linked up to the 1940 Arbitration Act.
Okay.
Where Lordship is aware, under the old Act, 1940 Act, an award of arbitrator had to be confirmed as a decree of civil court.
Yes.
So for that confirmation, you had to go to civil court, file a civil suit. This comes from there, my lord. But even in that situation, that proceeding in the civil court is a proceeding arising out of arbitration. So it cannot be contended by the respondents that this clause is confined only and only to a pure civil proceeding. Civil proceedings in the context of this agreement have to be proceedings arising out of arbitration, a Section 9 proceeding or Section 34 proceedings, which is the case in our in today's proceeding. So this is the first background fact. The award, the contract itself contains jurisdiction clause and an arbitration clause. Subsequently, disputes arose. Tribunal was constituted. 3 arbitrators were appointed. All 3 were from Delhi, undisputedly. No dispute about that. All 3 were from Delhi. Sittings, again undisputedly, were conducted exclusively in Delhi.
Yes.
No dispute. There cannot be any dispute about that. I submit that sittings being conducted in Delhi was purely on account of convenience of the arbitrators, simply because all 3 were from Delhi. There was no decision or conscious decision on the part of the tribunal or the parties that jurisdiction or venue of the proceedings is to be Delhi. It was only on account of convenience of the parties and the tribunal that Delhi was the constant venue of the proceedings. Fact number 2. Award was passed subsequently by the tribunal. Award was also published in Delhi itself. That was on 27th April 2019. 19.
Yes.
Now, award being passed, parties found that certain claims were against me. Respondent found certain claims were against the respondent. In respect to the claims against me, I filed Section 34 in Commercial Court, Shillong. Date of that is commercial case number 6 of 2019, which is the genesis of Lordship's proceedings today. Commercial arbitration case number 6 of 19. Date of filing, my lord, is important. The date when I filed.
Yes.
That is on 25th July 2019.
25/7/19.
That is, so this 34 was filed by me in Shillong on 25th July in respect of the claims which were decided against me. In respect of the claims which were decided against respondent filed his own Section 34 in Delhi. That is OMP bracket commercial 351/19.
Yes.
This was in Delhi. Date of filing, again, my lord, is important. 23rd August 2019.
Yes.
So Lordship will kindly see, almost a month after my filing, they filed their Section 34. Now, in the Shillong proceeding, they raised a preliminary objection through a formal petition, which is on record, my lord, raising an issue of jurisdiction. According to them, and frankly, I'm not sure what occasioned this submission. According to them, they filed previously in Delhi. A single point objection was raised that Shillong court does not have jurisdiction because, according to them, in their petition, they filed previously in Delhi and we filed subsequently in Shillong. As per Section 42, first filing being in Delhi means that all subsequent filings, including our filing, should have been conducted in Delhi. Single point objection was raised. Now, matter was heard by commercial court. That single point objection was adjudicated, my lord. My lord will clearly see the finding on that objection. That is at page 124.
Yes.
Page 124, para 19 of the impugn order, my lord.
Yes.
If I'm allowed to read this, para 19. The respondent does not dispute Annexure A and Annexure B of the rejoinder. Annexure A clearly establishes that the challenge to the impugned award dated so-and-so by the respondent by way of an application under Section 34 of the Act was filed on 23rd August 2019 before the Honorable High Court of Delhi. Annexure B, case status of the rejoinder establishes that the applicant, that is I, had filed an application under Section 34 of the Act 96 assailing the impugned award dated so-and-so on 25th July 2019 before the Commercial Court, Shillong. From the case history and the case status of both OMP so-and-so and commercial case number so-and-so, it is clear that the applicant had filed the incident application under Section 34 of the Act 96 before this court, Commercial Court, Shillong, prior to the respondent filing OMP so-and-so before the Honorable High Court of Delhi assailing the award dated so-and-so. The above conclusion is arrived at based on information available on records, which is not disputed by the parties. Objection was raised. Objection was answered. And conclusion reached that it was I who had filed previously, prior in time. Having filed prior in time, subsequent applications, including their 34, should have been filed in Shillong itself. My humble submission is this should have ended the matter. Matter should have ended there. However, upon no one's asking, with all due respect, Learned Commercial Court decided to investigate or examine its own jurisdiction. It was no one's case that Commercial Court Shillong had no jurisdiction. Now, I will, if Lordship allows, I will not take Lordship through the entirety of this order because it is something that takes up too much time on the last occasion also. I will take my lord to the finding, my lord, immediately. As to the jurisdiction, what is the finding of the court? Only one judgment was referred to, BGS Soma. Balco was not referred, no other judgments were referred, BGS Soma was referred, para 40, that is at page 136. 136, para 40 of the order. I'll read para 40, just the first part, my lord. That for the reasons discussed above and on analyzing the law laid down in BGS SGS Soma, this court finds that the place of arbitration was determined by the tribunal under Section 20 of the Act 96 Delhi. The Honorable High Court of Delhi will have an exclusive jurisdiction to entertain an application under Section 34 of the Act assailing the award dated so-and-so passed by the arbitral tribunal. Finding is that the tribunal had determined the place of arbitration to be Delhi. And the foundation for this finding as to why Learned Commercial Court came to the finding that tribunal had determined or decided the place to be Delhi, the foundation or the reason is at para 37, my lord, page 134.
Yes.
Para 37. Para 37, the argument of the applicant that is my argument, that the seat was not determined by the tribunal flies on the face of the record. The tribunal held its proceedings at Delhi. From its first sitting till conclusion of the proceeding, the impugned award dated so-and-so was published and signed at New Delhi by the presiding arbitrator and the member arbitrators. So I took the stand that tribunal had not determined or fixed the place or the venue as Delhi. Commercial Court's counter view was that everything happened in Delhi, proceedings conducted entirely in Delhi, award published in Delhi, therefore it cannot be said, therefore it has to be concluded that the place or the venue of arbitration was determined to be Delhi. Lordship, I will not go through any other portion of the impugned order. This is sufficient for today's hearing and I will explain how. Firstly, on the point of determination, my lord.
Yes.
Whether actually
any determination was done.
Any determination was done, my lord. Now, in this respect,
yes,
I will reiterate, my lord, the foundation or the ground or the reason of that conclusion. Everything happened in Delhi, sittings conducted in Delhi, award published in Delhi, therefore, place, venue has been determined to be Delhi. In this respect, my lord, I will request that I had filed a compilation on the previous round, compilation of authorities. If lordship would kindly look at that compilation, my lord. It looks a bit like this. It looks a bit like this with a blue thread.
Synopsis of arguments?
No. This one. This is the compilation. It's a.
No, this is the matter for Delhi High Court.
Yes, it's a compilation of various relevant documents, my lord. In this compilation, if Lordship kindly looks at page 19. Yes. Page 19, my lord, is a judgment of 2019.
Exploration.
Yes, ma'am. Yes. Again, my lord, at the risk of being repetitive, commercial court concluded that place was determined for the reason that sittings conducted in Delhi, award published in Delhi. Question is that enough? Supreme Court has answered that question at para 32 of this judgment, the next page, my lord. I've just given the relevant paragraphs. Para 33, rather. Para 33. Be it noted, the word determination requires a positive act to be done. In the case at hand, the only aspect that has been highlighted by Mr. So-and-so, learned senior counsel, is that the arbitrator held the meeting at Kuala Lumpur and signed the award. That, in our considered opinion, does not amount to determination. The clause is categorical. The sittings at various places are relatable to venue. It cannot be equated with the seat of arbitration or place of arbitration, which has a different connotation, as has been held in so-and-so versus so-and-so. So sittings being conducted in a place, award being published in a particular place is not determination. Yes. Either of the venue or of the seat. Determination requires, as per Supreme Court, a positive act to be done. The first line itself, my lord. Yes. Similarly, my lord, if Lordship goes back to page 18 of this compilation, it's 17 actually.
17?
17, my lord.
Determination.
Yes, my lord. From a law lexicon, Ramnath Iyer's law lexicon, at page 18 is a definition or an understanding of determination. Page 18, the first column, last entry, my lord. First column, page last 18. Entry. Okay. Last entry.
Expression.
Yes, ma'am. The expression determination signifies an effective expression of opinion which ends a controversy or a dispute by some authority to whom it is submitted under a valid law for disposal. Javanta Sugar Mills versus so-and-so, AIR, Supreme Court 1963 was referred to. So determination requires a positive act, a positive expression of opinion. Volumes have been submitted by the respondents, 4 volumes have been submitted containing multiple orders from the tribunal. There is not a single order where determination has been conducted, where a positive expression of opinion on the issue.
If I can remember, it says that, next date in Delhi again.
I'll come to that also. They are harping on that. They are harping on that. I'll address that issue also. But my point is that there is not a single, there has to be an order. There should be an order. If determination has been conducted, there should be an order saying, we decide that the venue of this arbitration or the seat of this arbitration shall be New Delhi. No such order is there. Instead, what the respondents are attempting to rely on is one order at page 2068 of volume 4. There is one order from in the middle of the proceedings, my lord. If Lordship kindly looks at that order, 2068. (2028) rather. 2028.
2028.
Now, 2028, my lord, is an order passed in the middle of the proceedings. I believe there is a typed copy. Hopefully, yes, Lordship has the typed copy.
Next page. Yes, 228.
Yes. I'll read, my lord. Arguments on the matter on the arguments on the matter on the application filed with the respondent under section 16 read with so and so has been heard in part. For further arguments in this application, the case will be taken up on so and so at 3:30 p.m. at the same venue. Mr. Sanjeev Rohtgi submits orally that the next hearing be fixed at Shillong. This suggestion can be considered only after a proper application is filed for change of the venue. Now, respondents are harping on this to try and impress or to convince this Honorable Court that the venue was fixed. Venue was not fixed by this date. There is no effective expression of opinion. The venue which is spoken of in this order is only the venue as far limited to the next date. Case would be taken up on so and so at 3:30 p.m. at the same venue. So the fixation of the venue for the next date was conducted through this order. If Lordship sees the next order, that is at page 2030.
2030.
That is the next date. It says, second line, the case shall be taken up for further arguments on so and so at the same venue. So again, there is an expression or there is a fixation of the venue for the next date. And this trend, this habit or this pattern is repeated consistently in every single order.
Okay.
So, point, my lord, is very simple, which I'm trying to drive home, is that if indeed at some point through this order 2028, page 2028 or some order in the past, venue was fixed, there would be no need to keep repeating the same thing in each and every order, that the venue will be the same, venue will be this, venue will be that. So this order itself, my first submission is, this order itself shows that venue was not fixed at any point.
You will say that by the very request that he made in Shillong, that means that the venue is not fixed.
Yes, that is my second point. The fact that Mr. Sanjeev Rohtgi made a request for the next date, he did not ask for a permanent shift, only for the next date, please shift it to Shillong. The fact that he had the ability to make that request shows that there was no venue fixed. If venue was fixed, it's a closed chapter. There would be no occasion for me or my law officer to have made that request, my lord. So to say that 2028 indicates or establishes that venue was fixed, with all due respect, my lord, that on the face of it, it's not correct, my lord. So determination of venue or the seat in no reading was conducted by the tribunal. So learned commercial court, with respect, arrived at a flawed conclusion, my lord. Now, the insistence of the respondent in trying to convince this honorable court that venue was actually fixed, the reason for that insistence, the reason for the effort they're expending is very simple, my lord. The reason is to be found in the BGS Soma judgment. That is at 2020 volume 4 SCC. Now, BGS Soma at several paras are there, but I think the most relevant to cut the matter short would be para 61. Para 61 of BGS Soma that is at page 289 of the volume.
Yes.
Para 61, I'll read, my lord. It will thus be seen that whenever there is an express designation of a venue and no designation of any alternative place as the seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indica, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitral proceedings. So, if respondent manages to convince this honorable court that venue was decided or designated or agreed at some point to be Delhi, then as per this position of law at para 61, that venue can become a seat. So if venue becomes a seat, the place of the seat, that is Delhi, will be given exclusive jurisdiction. So this is the approach of the commercial court also. This is the attempt on the part of the respondents before this honorable court also. What is evidently and obviously being missed out is that this is subject to one requirement. if I'm allowed to read again, it will thus be seen that whenever there is an express, number one, express designation of venue, there is no such
positive indication.
There is no such express designation of venue. On the last occasion, my learned friend tried to convince my lord that there was an implied designation.
Yes.
Implied is not enough, my lord. There has to be an express designation of venue, which is not the case. But even ignoring this aspect, and no designation of any alternative place as a seat, we have no such seat, combined with a supranational body of rules governing the arbitration, and no other significant contrary indica. And this is the fulcrum on which this case will turn.
Yes.
If there is a designation of venue, not our case, but let's assume for the sake of argument that somehow through my actions in attending the proceedings for 10-15 years in Delhi, somehow I have acceded to the venue being designated as Delhi. And because there is no seat, can Delhi, the venue, become the seat? It can become if there is no other significant contrary indica. In very simple terms, my lord, if in the arrangement between the parties in the entire litany of events, there is no indication that the parties wanted something else. Significant contrary indica, something significant.
So you say that request for Shillong indicates that this...
No. Then? Clause 58.2 is the significant contrary indica.
Okay.
Because clause 58.2 was the time when parties were of the same mind.
In Shillong.
Well, parties were of the same mind, and when both parties granted exclusive jurisdiction to Shillong courts. So my submission, which I will back up with the law, is that in this situation, firstly, there is no designation of venue. But assuming for the purposes of argument, if Lordship is convinced somehow or the other that there is a designation of venue, even then, Delhi, the venue, will not be promoted to the status of a seat, because between the parties there is clause 58.2, which is the significant contrary indica.
Yes.
Now, in the last round of hearing,
yes,
I had expended a lot of energy in trying to convince this Honorable Court that what I am saying is logical and therefore should be accepted. I could only rely on one judgment of the Allahabad High Court. In that respect, I'll come to that in a while, my lord. But my lord, today I am better armed for the reason that in the last 2-3 months, while we were waiting for those bullet points from the respondents, several high courts, including Delhi, Allahabad and Calcutta, have had the occasion to address the exact same fact situation. Venue in one place, jurisdiction in one place. Question is, which court will have jurisdiction? These high courts in multiple judgments have answered in my favor by stating that it is the court of the jurisdictional court where you have been granted jurisdiction. That court will have the jurisdiction, not the venue court, not Delhi. So,
I give the list of books.
I'm giving a compilation again, my lord. So, without wasting too much time, I'll just go to the compilation, my lord. My lord, page 1 of this compilation this is the second compilation I'm filing, my lord. Page 1. This is a Delhi High Court judgment.
Yes.
Now, Lordship may kindly look at para 5 of this judgment. Para 5, my lord, it relates, it reproduces clause 48 of the underlying agreement. Clause 48, if I'm allowed to read very quickly, my lord. All or any dispute arising out of or touching upon in relation to the terms of the lease deed, including the interpretation and validity of the terms thereof and the respective rights and obligations of the parties, shall be settled amicably by mutual discussion, failing which the same shall be settled through arbitration. The arbitration shall be governed by the Arbitration and Conciliation Act so and so, or any statutory amendments, modifications thereto for the time being in force. The arbitration proceedings shall be held at an appropriate location in New Delhi. So the venue was fixed in this clause. Moving on, my lord, this is the only relevant aspect from the arbitration clause, the venue was fixed. Moving on, my lord, para 15 of this judgment. Now, in our case, my lord, just to point out the obvious, that venue also was not fixed, but somehow assuming, for the purposes of argument, that venue was somehow fixed. Para 15, my lord. Main argument is in respect of the jurisdiction of this court to entertain the petition under section 11 of so-and-so act. It is claimed that under clause 49 of the lease deed, it has been clearly provided that the civil court at Gurgaon and High Court at Chandigarh alone shall have jurisdiction. Clause 49 reads as under, that the civil courts at Gurgaon and High Court at Chandigarh alone shall have jurisdiction. Same facts as our case. Venue or the proceedings were to be conducted in one place. Courts of some other place were granted jurisdiction. In this situation, the question that arose before the Honorable Delhi High Court was, did it have the jurisdiction to take up the section 11 petition? Answering, now, Lordship will quickly see page 7. In fact, not page 7, page 5, para 22 onwards, my lord. Now, I will not read all this, but para 22, Lordship will see reference to Balco has been made. Para 23, again, Balco has been discussed extensively. Para 24, my lord, Supreme Court judgment of Mankastu Impex Private Limited has been discussed. Para 25, my lord, Enercon India Limited Supreme Court judgment has been discussed. Para 26, my lord, Indus Mobile Distribution, we also referred to that, has been discussed. After discussing the entire law on this aspect, para 28.
Yes.
Oh, para 29. No, para 28, my lord. Para 28 is where the findings are contained. After discussing the entire chronology of cases that are applicable, my lord, para 28. Having discussed the distinct concepts of seat and venue, it may be examined how these two concepts have been interpreted and applied in various situations. In so-and-so versus so-and-so, arbitration petition number so-and-so decided on so-and-so by the coordinate bench of this court, similar clause came up for interpretation. The parties have agreed for venue of arbitration to be New Delhi, but in the other clause, they had agreed that all actions and proceedings arising out of related to the contract shall lie in the courts of competent jurisdiction at Guwahati. The court held that since the clauses of the agreement expressly provide that the courts at Guwahati would have exclusive jurisdiction, it was a contrary indicator coming within the exception as held by the Supreme Court in the case of, it should be BGS Soma judgment. Para 29, my lord. So clear finding that it should be the jurisdiction clause, my lord, the jurisdiction court. Para 29. Similarly, in Cravans Media so-and-so versus so-and-so, arbitration petition number so-and-so, decided on so-and-so by the coordinate bench, the dispute resolution clause provided that the venue of arbitration shall be Ranchi, but any disputes arising out of this agreement shall be subject to the sole and exclusive jurisdiction of courts in Delhi. It was held that the intention of the parties was clear that the seat would be in New Delhi and the court at New Delhi was held to have the jurisdiction. Para 30, my lord, the relevant clauses, clause 48 and 49 have been reproduced. I'll skip that part. Para 31, my lord. It is quite evident that there is a contraindication in the registered agreement that while the venue of arbitration may be New Delhi, but the seat of arbitration shall be Gurgaon and High Court of Chandigarh. In the circumstances, it has to be held that this court has no jurisdiction and it is the courts at Gurgaon High Court of Chandigarh which have the exclusive jurisdiction for entertaining the disputes arising out of the registered lease agreement. Lordship, I submit this is our case itself.
Yes.
Similar, exactly the same situation. In fact, in this case, the venue was determined. Our case is one step back. Venue was not even determined, my lord. But even as I said, for the purposes of argument, if it is assumed that venue is determined, even then, my lord, jurisdictional court will have to be held to be Shillong court because granting jurisdiction to Shillong under 58.2 is the significant contrary indicator.
Yes.
Moving on, next judgment, my lord, Calcutta High Court.
Yes.
Calcutta High Court, my lord. In fact, this was passed in June, not too long back, June of this year. Now, in this judgment, if Lordship kindly sees,
yes,
again, a similar kind of situation arose where venue was one place, stated to be one place, whereas jurisdiction was granted to another place, my lord. Now, here also the same question was faced by the Calcutta High Court. Para 6 of this judgment, my lord.
Analysis.
Yes, para 6 under analysis. I'm just highlighting. I'll read. The law on seat versus venue is a conundrum that has and still confounds courts to this very day. There is no crystal clear precedent point of view that shifts away the clouds of uncertainty that mystify this issue. However, various courts have attempted to give clarity in the said arena that I too shall dive into to demystify the same. Thereafter, the subsequent paragraphs, my lord, is again an analysis conducted by the Honorable Calcutta High Court of Balco, BGS Soma, Indus Mobile, etc., etc., etc. So the other paragraphs, my lord, to save time, I will not read. But there is a comprehensive examination conducted of Supreme Court judgments, of various High Court judgments. This analysis, my lord, goes on till para 18, my lord. Now, at para 18, Honorable Calcutta High Court refers to the Delhi High Court judgment which I had just read out, my lord. That is the Khushraj Bhatia judgment. Khushraj Bhatia was reproduced. Para 19 is the finding of the Calcutta High Court. Para 19, I find myself in consonance with the above view. In circumstances where a place is designated merely as a venue and courts of another place have been granted the exclusive jurisdiction, the latter is a clear contrary indica. It can be inferred from a comprehensive reading of such clauses that the venue is a convenient place of arbitration and not the seat. Para 21, my lord. This is a summation of the finding, my lord. Para 21. Contractual interpretation necessitates taking into consideration all clauses and relevant factors to propound the proper intention between the parties. The rule of harmonious construction must be applied so that a panoramic meaning can be given to any agreement. The law with respect to arbitration clauses as laid down in BGS, SGS, Soma and Mankatsu Impex is not alien to such interpretive principles. In light of the Apex Court's decisions in these two judgments, other clauses have to be scrutinized. When a location has been mentioned as venue or place to fathom if such a location can be dignified with the status of seat. In my opinion, a clause opting a place as venue or place read with another clause which mentions courts of another location to have jurisdiction over disputes that may arise inhibits the promotion of such venue to seat. The intention that emerges from an aggregate understanding of such clauses is that the venue or place was to be a convenient location for holding of arbitration seatings. The courts of the place selected as having exclusive jurisdiction over disputes should be considered a seat and having jurisdiction to entertain applications under the Act. Again, my lord, humbly I submit that this is our case all over again, my lord. Third judgment.
Allahabad.
Allahabad, my lord. This is a 2022 judgment. Para 2 of this judgment. The facts are there. Para 2, Mr. Mathur, learned senior advocate appearing for the applicant, submitted that an agreement was signed between the applicant and respondent so-and-so, hereinafter so-and-so, on so-and-so, for distribution of electricity in urban areas of Agra, for which the respondent was a distribution licensee. Clause 17 of the agreement provides for resolution of disputes between the parties. Clause 17.2.5 provides for arbitration. Clause 17.1.2 provides for jurisdiction of the court for entertaining all the disputes between the parties. It has been mentioned as Agra, Allahabad. The venue of arbitration has been provided under clause so and so to be at Lucknow. So venue was Lucknow. Courts of Agra and Allahabad have been given jurisdiction. In this background, my lord, what is the finding? Para 13 of this judgment, para 13 onwards, my lord. Para 13 onwards is again an analysis and examination of the law. BGS, para 14, they refer to another judgment, para 15, another judgment, para... it goes on, my lord. N number of judgments, after referring to n number of judgments, para 19 is the conclusion, my lord.
Yes.
Para 19, my lord. Applying the aforesaid law in facts of the present case, there appears a contra-indication in the agreement to an extent that the venue of the arbitration is stipulated to be Lucknow, whereas the courts at Agra and Allahabad are given exclusive jurisdiction in case any dispute arising out of compliance, non-compliance of the agreement. From the jurisdictional perspective, Lucknow is only a venue or location for conducting the arbitral proceedings. The exclusive jurisdiction clause contained in the agreement constitutes significant contrary indica as per Shashwa principle, and only the courts at Agra, Allahabad will have jurisdiction to decide the disputes between the parties arising out of agreement in question. So specific reference to Shashwa principle, which requires the absence of a significant contrary indica, court is very clear that your jurisdiction clause is that significant contrary indica, my lord. Last judgment, my lord, Delhi judgment, Honorable High Court of Delhi again. Para 3 of this judgment, my lord. Para 3 has reproduced the arbitration clause of their underlying agreement. The portions are already highlighted in the extracted clause. I'll just read the portions in bold, my lord. Arbitration proceedings shall be held at the corporate office of the developer alone in New Delhi by a sole arbitrator. So the venue was fixed to be New Delhi. The next highlighted bold portion, my lord. The arbitration proceedings shall be held at New Delhi, and the courts at Gautam Budh Nagar, Uttar Pradesh shall, to the specific exclusion of all other courts alone, have the exclusive jurisdiction. So, venue Delhi, jurisdiction to Gautam Budh Nagar. In this background, again after discussing the entire law on this, para 14 was arrived at. Para 14, my lord. Upon a conspectus of the averments contained in the petition and in the reply, and based upon the submissions made in the opinion of this court, the following inferences arise. I'll skip to inference 14.3, my lord.
Yes.
Though, as noted above, multiple judicial precedents have been cited by both sides, this court is persuaded to follow the interpretation given to a very similarly worded arbitration clause in a recent decision of a coordinate bench of this court in Khushraj Bhati, the first judgment, my lord. Khushraj Bhati, where the court was dealing with an arbitration clause which reads as follows. I'll skip the clause, my lord. In the above case, after referring to the extant legal position and in view of the contraindication in the agreement whereby the venue of arbitration, namely the place where the arbitration proceedings were agreed to be held, was New Delhi, but the seat of arbitration would lie within the territorial jurisdiction of the civil courts at Gurgaon and the High Court of Punjab and Haryana at Chandigarh, the coordinate bench decided to decline to entertain the arbitration petition for lack of territorial jurisdiction. Next, my lord. The arbitration clause in the present cases similarly worded, and therefore, in the opinion of this court, New Delhi is referred to in that clause only as the location for conducting arbitral proceedings. However, from the jurisdictional perspective, the parties have expressly agreed to territorial jurisdiction vesting in the courts at Gautam Budh Nagar, Uttar Pradesh, and the Allahabad High Court as may be applicable, depending on the proceedings in question. Para 15. Accordingly, it is held that this court does not have territorial jurisdiction to entertain or decide the present petition. So, again,
the substance, you say what is immaterial. whatever has flown under the bridge. Once, and 58.2 has given that indication that the jurisdiction will be with the Shillong courts, so it's immaterial wherever you sit A, B, C, D.
There is no running away from the fact that proceedings were entirely held
by
in
conduct or by convenience. You're sitting in Delhi. Doesn't mean that
there is no running away from that fact that everything happened in Delhi. Proceedings were conducted in Delhi. Award was published in Delhi. There is no dispute or running away from that fact. But that fact, even if it grants these a status of venue to Delhi, will not promote that status of venue to the status of a seat. Why? Because of the presence of a significant contrary indica, that is 58.2. And the reason, my lord, would have noticed, I had highlighted the fact that multiple references or judgments have been analyzed of Supreme Court, BGS, Soma, Balco, etc., of various high courts while passing these judgments, is for the reason that these are well-speaking orders, my lord, based on, in my humble submission, unimpeachable logic, my lord. Now, I would only request that Lordship finds it convenient or proper to be persuaded by the logic of these judgments and reach a similar conclusion, my lord. Just one more judgment I have in this respect. On the last occasion I had referred to it, but just for completeness, if Lordship allows me to refer to it again, that is the judgment at page 29 of my earlier compilation, my lord. Allahabad. Page 29.
Allahabad judgment.
Allahabad, my lord. So I had extensively referred to this judgment. I will not extensively refer to it, but again request my lord to kindly appreciate that this is also has made multiple references or has analyzed the extant law, that is starting from para 18 at page 38 of the compilation, para 18. From para 18 onwards, my lord, the entire judgment is thick with analysis and examination of Balco, of Shashwa case, of various other cases, my lord. The entire history has been laid out. On the last occasion, my lord, I had said that this is a very good judgment for my purposes, for the reason that this is a very lucidly written, in very simple terms. They have examined the existing law. After examining the law, para 34 is where the conclusion has been reached, my lord. That if this law is to be applied, law of Balco, BGS, Indus Mobile, etc., para 34 is the conclusion. Here also, same thing. Venue was New Delhi, jurisdiction granted to Gautam Budh Nagar, Uttar Pradesh. Para 34, my lord. In the present case, the arbitration agreement clearly shows that the parties agreed as per clause so-and-so that the governing law and the jurisdiction of the courts would be the courts of Gautam Budh Nagar, UP, India, and it shall have jurisdiction over all matters arising out of or relating to the allotment, provisional allotment, subject to the provisions of clause so-and-so of the standard terms and conditions. This exception regarding clause 10.9 constitutes significant contrary indica as per Shashwa principle in agreement regarding treating the venue of arbitration, New Delhi, as seat of arbitration proceedings, Gautam Budh Nagar, where the cause of action arose. In clause 10.9 regarding dispute resolution, it was agreed that the venue of arbitration shall be New Delhi, India. Accordingly, the sole arbitrator conducted the arbitration proceedings at the agreed venue of New Delhi, like our case, and passed the award, like our case. From the standard terms and conditions agreement between the parties, it is clear that the parties never clearly stated about the seat of arbitration, like our case. But from clause 10.6 of the agreement, the courts at Gautam Budh Nagar, UP, India was agreed to have jurisdiction over all matters arising out of or in relation to the allotment, provisional allotment. This clause proves that the parties had chosen the seat of arbitration as Gautam Budh Nagar, UP, and the venue of arbitration as New Delhi, India. So if seat was chosen as Gautam Budh Nagar, jurisdiction would be with Gautam Budh Nagar. In our case, seat has been chosen to be Shillong. Jurisdiction has to lie with Shillong courts, my lord. So, to sum up, my lord, without I'm sure I'm within my time limit, but just to quickly sum up.
Anyway.
Just to quickly sum up, my lord. The law is very clear, my lord. The law is very clear that if there is no significant contrary indica, then your venue can become your seat. If venue becomes seat, then jurisdiction is with the seat. If there is no significant contrary indica. All these judgments, some six of them, various high courts have held that if there is a jurisdictional clause granting jurisdiction to one particular court, that clause is the significant contrary indica. Same, which is the case in today's proceedings, my lord.
And your other case is that there is no express designation in the proceedings.
There is no express designation.
That is your only thing.
Yes,
so that 15.2 will hold sway.
Yes, my lord.
Over,
So if
over and above everything else.
Yes, my lord. So if lordship agrees with me that there is no express designation,
that is your submission. That is no express designation. Even the 2028 which you referred to is just that even the request for change of venue, it's doesn't means that there's been no agreement.
There is no decision or agreement.
Or no positive indication as to
yes, yes,
right. Positive determination rather.
Yes, yes, ma'am. And one last aspect which I'm required to highlight is that in some judgments, especially BGS, reference, maybe I should read this paragraph because it's very, very crucial for me. Paragraph 59 of BGS case, my lord.
What about the test for determination? This BGS has laid down.
Test for determination.
The test for determination. I think the judgment has elaborated on that also, right?
Test for determination of venue, my lord.
Yes. We'll not go there. 59. Okay.
Yes, my lord. I've already referred to that. The test for determination was in para 61, my lord.
Okay.
Which I had read.
59.
59.
Yes.
On the last occasion, my lord, I had read 59 and I had said that this heals the issue in my favor.
There was a bit of confusion, with due respect, in antrics and this whatever.
There is, yeah. But if the unnecessary chaff is cut away, issue becomes very simple, my lord. Issue becomes very concise and precise. Para 59, my lord, I think answers that issue very clearly. Para 59, I'll read, my lord. Equally incorrect is the finding in Antrix Corporation Limited that Section 42 of the Arbitration Act in 96 would be rendered ineffective and useless. Section 42 is meant to avoid conflicts in jurisdiction of courts by placing the supervisory jurisdiction over all arbitral proceedings in connection with the arbitration in one court exclusively. This is why the section begins with a non-obstante clause and then goes on to state where, with respect to an arbitration agreement, any application under this part has been made in a court. It is obvious that the application made under this part to a court must be to a court which has jurisdiction to decide such application. The subsequent holdings of this court that where a seat is designated in an agreement, the courts of the seat alone have jurisdiction would require that all applications under part 1 be made only in the court where the seat is located, and that court alone then has jurisdiction over the arbitral proceedings and all subsequent applications arising out of the arbitral agreement. So read, Section 42 is not rendered ineffective or useless. Also, and this is what I'm stressing on, madam, also, where it is found on the facts of a particular case that either no seat is designated by agreement, our case, my lord, or the so-called seat is only a convenient venue, our case, my lord, then there may be several courts where a part of the cause of action arises that may have jurisdiction. So this, I believe, answers the issue, my lord. Supreme Court is very clear. When no seat is designated and where your venue is only a convenient venue, then there may be several courts where cause of action arises which will have jurisdiction. An example has been given, my lord. Again, an application under Section 9 of the Arbitration Act 96 may be preferred before a court in which part of the cause of action arises in a case where parties have not agreed on the seat of arbitration, and before such seat may have been determined on the facts of a particular case by the arbitral tribunal under Section so-and-so of the Arbitration Act 96. In both these situations, the earliest application having been made to a court in which a part of the cause of action arises would then be the exclusive court under Section 42, which would have control over the arbitral proceedings. For all these reasons, the law stated by so-and-so, so-and-so. So, when a petition is filed in a court where the part of the cause of action arises, that court becomes the Section 42 court. which attracts all other subsequent petitions, they have to be filed in that court, my lord. And that court has the jurisdiction. Why?
Yes.
Because part of the cause of action arose within that court. So the limited question now to be answered is, did any part of the cause of action arise within Shillong? It did, my lord. The agreement was signed in Shillong. If the agreement was signed in Shillong, is that sufficient to grant Shillong court the jurisdiction? Answer is yes, my lord. Answer can be located, my lord, in my compilation at page 60. In para 59, my lord, they have reiterated Balco. Balco also said the same thing, that two courts have jurisdiction. One, where your seat is located, or two, where your cause of action arises. So para 59, my respectful and humble submission would be the answer to the conundrum, as Calcutta High Court called it, that is facing this honorable court, my lord. As I was saying, my lord, the limited question now to be answered is, did any cause of action arise? Yes, agreement was signed. Is that enough of cause of action? Page 60 of my compilation may kindly be looked at, my lord.
60.
60. Page 60, my lord.
Yeah.
Para 8 of this judgment, my lord. Para 8, my lord. This conclusion was approved by the Supreme Court in the case of so-and-so. That being the case, it can safely be said that the contract in the present situation was concluded at New Delhi, that is, the place where the acceptance was received. A similar line of thought is discernible in the case of ABC Laminat, where the Supreme Court was of the view that the making of the contract constituted a part of the cause of action and that the acceptance of an offer and its intimation results in a contract, and therefore a suit could be filed in a court within whose jurisdiction the acceptance was communicated. These two decisions of the Supreme Court, which was cited by the learned counsel for the petitioner, makes it abundantly clear that the making of the contract constitutes a part of the cause of action and that the contract so-and-so was made at Delhi. Making of the contract is enough cause of action. Para 59 of BGS says, if your seat is not designated and your venue is only just a convenient venue,
multiple jurisdiction,
where part of the cause of action has arisen also, you can file it. I have filed in Shillong because part of the cause of action has arisen.
Was it correct last occasion, if I remember correctly, for some other claims you filed it in Delhi also?
No, that was they filed.
Oh, you had not filed there?
No, we had not. We have challenged jurisdiction in that case also. That is still pending, my lord.
Anything else?
That is all, my lord. I reserve my right to respond on any law.
Yes, Mr. Paul.
Obliged.
Yes, please, lordships. My learned friend, my lords, in the garb of actually sorting out the confusion has actually confused me also.
Yes.
Well, I will take your lordships, and as a matter of fact, this was argued before your lordships in the first round of arguments. We had taken your lordships first to
which you all effectively buried after that.
I'm sorry.
We couldn't dispose, you all buried the hearing after that.
My lords, my lords.
Yes.
I had taken your lordships first to the arbitration clause itself.
Yes.
Because all these judgments that my learned friend has now placed before your lordships, my lords, would have to be read in connection with what is the arbitrable clause, or what is the cause which can be arbitrated under the agreement.
Yes.
The lordships had taken note of the fact that this was an arbitration to be conducted under the old Arbitration Act of 1940.
1940, right.
Your lordships would find that at page 39 of the revision application.
Yes.
Now, your lordships at page 38 will notice effect and jurisdiction, my lords, is clause 58, which my learned friend was referring to, 58.2.
Yes.
Now, effect and jurisdiction, Willits. It says the court situated at a place where the headquarters of the corporation is situated, Shillong will have jurisdiction to entertain suits pertaining to the contract. Now, after 58.2 comes 71, which is the arbitration clause.
Yes.
Now, I will read this arbitration clause a little slowly, Millets, for my understanding. The agreement authority for this contract is the Northeastern Electric Power Corporation and is represented by the chief engineer as far as this contract is concerned. The chief engineer is represented at site of work by project manager, superintending engineers, executive engineers, subdivisional officers, assistant engineers, junior engineers, and other subordinate staff. The officers at site are delegated with certain powers regarding execution, measurement, and payment of works. The commitments made by these officers at site and the chief engineer are based on interpretation of agreement made by them. It may sometimes happen that the corporation chief engineer does not agree with the views of his subordinate officers and may have, it should be an entirely different view as far as the interpretation of a clause in the agreement is concerned. In such cases, the corporation chief engineer shall have the full right to revoke the decisions made by his subordinate officers and direct adjustments in payments based on final decisions of the corporation chief engineer. Such decisions of the corporation chief engineer shall be communicated to the contractor under the title Decisions Revoked by the Chief Engineer Corporation and shall be binding on the contractor. Number 2, B. Subject to the above stipulations, if the contractor considers any record or ruling of the corporation chief engineer or his subordinates so authorized in respect of any work demanded by him by the chief engineer to be outside the requirements of the contract, he shall immediately upon such record of ruling being made or such work being demanded ask in writing for instructions, protest with the chief engineer, stating clearly in detail the basis of his objection, except for such protests or objections as are made on record in a manner herein specified, and within the time limit stated, the record rulings, instructions or decisions of the corporation of chief engineer, it should be corporation or chief engineer, shall be final and conclusive. Instructions and or decisions of the chief engineer contained in letters, transmittings, drawings to the contractor shall be considered as written instructions or decisions, subject to protests or objections as herein provided. Then, Millets, if the contractor is dissatisfied with the final decisions of the chief engineer or corporation on the protest or objection made by the contractor or in accordance with the procedure prescribed in paragraph 17.1b, the contractor may within 15 days after receiving notice of such decision give notice in writing to the chief engineer requiring the matter to be submitted to arbitration and furnishing detailed particulars of the dispute or difference specifying clearly the point of issue. If the contractor fails to give such notice to the chief engineer within the period of 15 days as stipulated above, the decision of the chief engineer shall be final and conclusive and binding on the contractor. Thereafter, such issue shall not be subject to arbitration. Arbitration shall be effected by an arbitration board consisting of 2 members, one selected by the corporation, other by the contractor. The provisions of the Indian Arbitration Act 1940 and the rules thereunder shall apply for appointment of umpire and all matters relating to arbitration proceedings. No arbitration shall be commenced without specific terms of reference. The cost of such arbitration shall be borne by the parties as the party decide by the arbitration board. If work under the contract has not been implemented, so and so, the work shall continue, well, it's not relevant. What I'm coming to is, and which would be a stark difference from all the judgments that have been placed before lordships. In all the judgments, the expression used is all disputes arising out of the contract would go in for arbitration, as is the standard clause that is used these days. Here is an exception, Manoj, that these issues, there may be a difference of opinion between the person on site and the chief engineer with regard to measurements. Then the chief engineer would make an order. And only on those orders, Manoj, when it is communicated to me, I may invoke arbitration, I may not invoke arbitration.
Okay.
So the question therefore arises, Manoj, is whether 58.2 can be given the interpretation which my learned friend is giving.
All encompassing.
If it is all encompassing, my lords, yes.
That's the definition that he's
exactly, my lords.
Yes.
Which is why I started off by saying, my lords, while trying to, my lords, sort out the issue, my learned friend has confused me more. And which is why I had to go back to the arbitration clause itself. It is not an all-encompassing arbitration clause.
Okay, 58.2.
If it is not an all-encompassing arbitration clause, my lords, 58.2 cannot be given an interpretation which is sought to be given by the petitioners before your lordships.
Okay.
It is these specific issues which are there for arbitration. So what they are saying, my lords, that regarding the jurisdiction of courts being invoked would essentially have to be under an arbitration, and my learned friend was referring to section 8. That even if there is a suit, courts would have to refer them to arbitration, not necessarily under this contract. There would have been issues which could have been outside the arbitration, for which purpose the jurisdiction of courts under 58.2 could have been invoked.
Okay.
Which is why, my lords, the framers of the agreement put arbitration at 71 and put jurisdiction of courts at 58.2. Lordships, in the usual format which is usually there, jurisdiction of courts is usually after the arbitration clause is laid out.
Yes.
Now, that is the first distinguishing factor insofar as all these judgments are concerned. I'll have to deal with them individually.
All the judgments?
My lords. I would have to, my lords.
How much time will you take? Yes.
My lords, my friend said 15 minutes plus minus 5, he took 35. So, I would take a little bit of time.
Yes, yes.
So, that is the first issue that I have to employ before your lordships. Now, in this context, my lords, the judgments of the Honorable Supreme Court are very specific. That the issue with regard to seat of a court and venue or seat of arbitration are completely different subject matters. They cannot be, well, it's interchangeably looked into as a same issue, which unfortunately, well, it's in all the judgments which have been placed before your lordships, that kind of a view has been taken by the court, citing a contrary indicia. In my humble submission, well, it's that cannot be considered as a contrary indicia. I will come to all the judgments, well, it's on the factual aspects as well. Now, the second issue which has been urged by before your lordships is that the admitted position of the parties is that the arbitration was held in Delhi.
Yes.
All sittings of the arbitration were held in Delhi. The award was signed in Delhi. It was stamped in Delhi and published in Delhi. Now, my lords, I will take your lordships to the Arbitration Act if your lordships kindly have section 31. My lords, form and contents of the arbitral award.
Yes.
An arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. For the purposes of subsection 1 in arbitral proceedings with more than one arbitrator, the signatures of the majority of the arbitrators of the arbitral tribunal I'll skip all this, my lords, your lordships will come straight to 4. The arbitral award shall state its date and the place of arbitration as determined in accordance with section 20. And the award shall be deemed to have been made at that place. Now, let us read section 20 minutes. The parties are free to agree on the place of arbitration. Failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. Notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation amongst its members, not relevant for our purposes. Also, my lords,
yes,
the arbitration award would essentially, my lords, say where the arbitration is held. Because your lordships are aware, and the conundrum that we're talking about is because, my lords, there's nobody, that act does not define either seat or venue. It just says place of arbitration.
Yes, the act does not define seat.
My lords.
Yes.
So, Subsection 4 of section 31, my lord, says that the arbitral award shall state its place, date and place of arbitration and determined in accordance with section 20, and the award shall be deemed to have been made in this place.
Right.
Now, my lords, the application that was filed by the petitioners is an application under section 34. If you may very quickly go to section 34, my lords.
Yes.
Application for setting aside arbitral award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. An arbitral award may be set aside by the court, party making the application, my lords. So what we are essentially dealing with is that an award which is made in Delhi, admittedly, can it be set aside by a court in Shillong on the ground that there is some indication somewhere that the parties have decided?
Yes, the first question.
It is a question, my lords, that goes to the root of the entire matter. Because subsection 4, they would have to first satisfy all courts in Shillong that you otherwise have territorial jurisdiction to decide this issue. Because you are coming before this court under section 34.
Yes.
Now, what has been sought to be urged before your lordships, my lords, is a double-edged sword. In one breath, my lords, the petitioners say that there is no seat or venue. So the contrary indication would have to be taken into note, and they come back to 58.2. In the second breath, my lords, what they're trying to suggest is that cause of action has arisen in different parts, and so therefore all courts having where some part of the cause of action would have jurisdiction in that matter. That is no longer sub judice before any, it is no longer res integra, my lords. What my learned friend was reading at paragraph 59 of B.J. Soma, if I may read it again. B.J. Soma actually, my lords, that particular paragraph is observing the pronouncements of the Bombay High Court and some other court, my lords, and where they say they overrule it. I'll quickly take your lordships back to paragraph 59.
No, if I'm not mistaken, I think because there's some difference with international arbitration and domestic arbitration.
Absolutely.
That's why this confusion arose. With regard to this, domestic arbitration should be different, and regard to
commercial arbitration,
international arbitration has to be this. That's the thing.
But para 59, well, is what was being referred before your lordships. What does it say?
Yes. 59.
My lords, I will skip reading the entire thing, that is not relevant. Your lordships have already read it. Just last 4 lines, let us read from them, my lords. Also, where it is found on the facts of a particular case that either no seat is designated by agreement, the so-called seat is only a convenient venue. There may be several courts where a part of cause of action arises may have jurisdiction. Again, an application under section 9 of the Arbitration Act 1996 may be preferred before a court in which part of the cause of action arises. In such cases where parties have not agreed to the seat of arbitration and before such seat may have been determined on the facts of a particular case by an arbitral tribunal under section 22 of the Arbitration Act 1996. In both these situations, the earliest application having been made to a court in which part of the cause of action would have been the exclusive court under section 42, which had of control over the arbitral proceedings. For all these reasons, the law stated by the Delhi and Bombay and Delhi High Courts in this regard is incorrect and is overruled.
Yes.
Because Balco also says the same thing, my lords. You cannot have concurrent jurisdiction of 2 courts.
Yes.
Now comes the question, my lords, that the entire proceedings are in Delhi, and I come back to my compilation, my lords, and what I had already submitted before your lordships on the last occasion. These 2 orders are very relevant, and that is why I flagged it in the first place.
So you rely on para 61 of BGS then?
My lords, that is the law. Unless, my lords, set aside by some.
So it says venue will mean the seat.
Has to. Your lordships, because I asked myself this question. If an arbitration proceedings are held here in Shillong, my lords, would a court, let us assume, my lords, in Darbhanga in Bihar, would have jurisdiction to then entertain an application under section 34?
Why Darbhanga? Why you choose Darbhanga?
Well, it just came. Budnagar was coming also, Darbhanga came.
Okay, yes.
Or maybe let us take, my lords, whether the courts in Delhi had the contrary being there in the instant case, my lords, that the entire proceedings of the arbitration were held in Shillong.
Yes.
Would then the courts in Delhi have jurisdiction to entertain an application under section 34? That goes to the root of the entire matter. Now we come back to, my lords, page 2028.
Yes.
Because that same venue thing, well, as I pointed out earlier also, every order says same venue. Now, Mr. Sanjeev Rohtgi orally submits orally that the next date of hearing be fixed at Shillong. This suggestion can be considered only after proper application is filed for change of venue.
It's a bit confusing.
My lords, for change of venue. Let us forget the sentence
It's been a
prior
bit
to
confusing because that means that there's been no fixed venue.
There is a fixed venue, my lords. Unless there is a venue, my lords, there cannot be a question of change of venue. A change can be there only when something is static.
It doesn't change our designated venue. It's just change of venue.
It need not say designated venue, my lords. The very fact that for 16 years a proceeding is going on in Delhi with active participation
Because the whole
by the
thing will
petitioners.
rest on this. Because if you want to say that the venue will constitute a seat, then you have to satisfy this court
that there is determination.
That's a positive determination with regard to the
My lords,
venue.
the positive determination is the award being signed in Delhi.
Fine, because the thing
Which is
that
why I took your lordships to 31-4.
Starts from the convenience.
Maybe for the
Yes.
purposes of convenience, my lords.
Yes.
Which is why section 31-4 makes it very specific. And I'll read section 31-4 again for the convenience of this honorable court, my lords. The court or arbitral tribunal, I'm sorry, my lords, 31. I'm sorry, I'm reading something else. The arbitral award shall state its date and place of arbitration as determined in accordance with section 20, and the award shall be deemed to have been made at that place. So there is two requirements, my lords, which is why I had submitted the act does not provide for either seat or venue. The act only provides for place of arbitration. 31-4 makes it obligatory on the part of the arbitrators that at the time of signing the award, you will mention the place.
The form and contents of the award.
My lords, you will mention the place.
Okay.
And that shall be deemed to be the place under section 20 of the act. Okay. So the determination which has been urged before your lordships is the award. If the award was not there, my lords, then I would have my back to the wall. The determination, my lords, is made the very fact that it is signed in Delhi and it is stamped in Delhi. Your lordships would aware that the arbitration award would have to be stamped. It is stamped on a stamp paper of Delhi. And that itself is a determination of place of arbitration under section 20.
Okay.
So, my lords, I come back to this page 2028. What has been submitted before lordships is there is no determination of venue. My lords, if we are to read this paragraph again, Mr. Sanjeev Rohtgi submits orally that the next date of hearing be fixed at Shillong. This suggestion can be considered only after a proper application is filed for change of venue. There are two aspects to the matter. First is a simpler aspect, my lords, that they made an oral prayer but they never filed an application.
Okay.
That is borne out by the subsequent orders. So by conduct, they are now stopped from questioning the fact that the venue of the arbitration was in Delhi.
Yes.
That's one. Now, my lords, if we are to break this certain paragraph and read it more carefully, it says, this suggestion, number one, it is a suggestion, can be considered. Considered, my lords, would have to be a determination, again, only after a proper application is filed for change of venue. What is the application to be filed? For change of venue. When can an application be filed for something to be done, my lords? When something is already there. If your lordships
Can
have...
we read that into this, because there's no...
May I draw an analogy, my lords? Okay. Unless there is an order passed by your lordships would I be in a position to file an application seeking alteration, modification or change of that order?
Okay.
It is on the fundamental premise that there is an order. Once there is an order, my lords, then I can make an application before your lordships that kindly change that order in these facts and circumstances of the case.
Okay.
So it would be not correct to say that there was no determination of seat or of venue. And which is why, my lord, consistently the tribunal continues to say same venue, same venue, same venue. And it says in this order, we'll consider it provided you file an application.
Okay.
So then the second question comes is, my lords, whether an application has been filed. Answer is in the negative.
No application was filed.
No application filed. Because this order is dated, my lords,
it's dated November
2/11/2006. And the award came to be passed in 2019. So a good 13 years after that, my lords, they decided to participate in the proceedings in Delhi. And after having participated for a good 19 years in Delhi, then they come before your lordships and say, oh no, very well, now because of 58.2, I will move a section 34 application before the courts in Shillong.
Okay.
Now coming back, my lords, to the judgments that have been placed by my learned friend before your lordships.
Now you come to P2030. Again, it says the clerk counsel for the claimant address his arguments. So the case shall be taken at the same venue.
Same venue.
So
the moment you say same venue, my lords, there is a determination of venue. The preponderance has to be on the fact that there is a determination of venue.
Okay.
Only if there is something, my lords, if I may.
That is a year later. I mean, that is 2007.
Yes. All orders, my lords. After that also, there are numerous orders. That's what I was just checking. 2011. My lords, at page 2021. Sorry, 2121.
Okay.
This is an order of 10/3/2021. Let's take up the award from this. This is the award?
A long order.
No. 2121, my lords, is a very.
Page 121.
Well, it's 002121. It's just 3 lines, my lords. Same venue. On the top right hand corner, my lords, is the page number.
Right.
I'm sorry, my lords. It's 2127. My apologies. It's appearing as 2121. It's 2127.
Same venue.
No, same venue. This is passed in 2011. Well, if I may again,
yes,
the indulgence
please
of your
continue.
lordships, well, to again draw an analogy. Well, we in our younger years we would say that we would come back to play cricket or play football on the same ground or some other ground. Now, unless there is a determination of the ground where we are playing, melodies, there is the word "same" would have no connotation. It would essentially have no meaning. Unless, melodies, there is an agreement of minds with regard to a certain thing, an act to be done in a certain fashion, or not to be done, melodies.
Yes.
Same would essentially lose all its meaning. Same would mean, my lords, that there is already an agreement and we continue with the same agreement. So the moment, my lord, same is there, that means there is a determination of venue.
Okay, so according to you, that means positive determination is a done deal.
It is done, my lords, and
there's no question of,
it is sealed by that order. And it is sealed by that order of.
So you say positive determination already exists, and the order of 20 in that 2007,
211/2006
yes, 2006 whatever.
seals the matter in my favor because they talk about change of venue.
Yes. The 2028 pages.
Yes, it talks about change of venue. So unless there is determination of a venue, where is the question of change of venue? And the fact that somebody on behalf of the petitioners is making a request, an oral request at that stage, and it's not even a request, a suggestion of change of venue, that means, well, he's aware that there is a venue which is set. Unless there is something I know which is set, why will I ask for a change?
Okay. Yes.
I will take your lordships to the award, my lords, as a volume 1 of that 4 compilations which we had given to your lordships.
You're done with volume 4?
Volume 4, my lords, is the orders. So I've placed the orders. My lords.
Page 59.
Page 59. Your lordships had taken note of it on the last occasion, my lords, that this award is made and published at so-and-so flats, East Mukherjee Nagar, Delhi, on the 27th day of April 2019 and has been printed on stamp paper of rupees so-and-so, so-and-so. So this is the determination that we're talking about. As a matter of fact, my lords, I will go back to the compilation filed by my learned friend and the meaning as given in the law lexicon, my lords.
Expression.
The expression determination signifies an effective expression of opinion which ends a controversy or a dispute by some authority to whom it is submitted under a valid law for disposal.
So you mean the award is a...
It is the award.
Yes.
Meaning the final award. If I may read it again, my lords, the expression determination signifies an effective expression of opinion, meaning a final expression of opinion, which ends a controversy or a dispute by some authority to whom it has been submitted under valid law. So under valid law, my lords, the parties go in for arbitration. There is no question that there was no arbitration and yet the arbitrators decided something. Both parties submitted to arbitration. You participated in the arbitration proceedings. And under valid law, by way of the final award, my lords, the arbitral tribunal does its job and closes the matter. Then it is for both the parties to take it here and there, wherever. So the determination, which is why, my lords, 31(4) says that what you mention in the award shall be determination of the place of arbitration, shall be deemed to be the determination of the place of arbitration. So this sets the controversy at rest.
Yes. Yes.
Well, there's a BJS Soma. Well, it's paragraph 98, if I may just place this paragraph 98 before your lordships. Para 61, my learned friend has already read. 98, last page. It's the second last paragraph of the judgment.
Yes, 93. However,
the fact that in all the 3 appeals before us, the proceedings were finally held at New Delhi and the awards were signed in New Delhi and not at Faridabad would lead to a conclusion that both parties have chosen New Delhi as the seat of arbitration under Section 21 of the Arbitration Act 1996. That being the case, both the parties have therefore chosen that the courts at New Delhi alone would have exclusive jurisdiction over the arbitral proceedings. Therefore, the fact that a part of the cause of action may have arisen at Faridabad would not be relevant once the seat has been chosen, which would amount to an exclusive jurisdiction clause so far as courts of the seat are concerned. This would have to be read in conjunction with paragraph 61.
Okay. But this is to regard the second argument regarding cause of action. His whole thing is based on 58.2.
58.2.
That is his whole,
My lords, which is why I first started off my argument saying this, because I had dealt with this matter in detail in the last occasion also. Your lordships have taken the pains of going through Balco, Vijay Soma, Brahmani River Pellets. I don't want to burden your lordships with that. But the fact of the matter remains that 58 is only with regard to jurisdiction of courts with regard to certain issues. Because if
you already submitted that, yes.
Lordships, because had the entire gamut of the agreement been under arbitration, my lords, that would definitely come into play. But unfortunately or fortunately for me in this case, my lords, only specific things are therefore open for arbitration. There would have been other issues which would have been gone before a civil court. So Section 8 per se of the Arbitration Act would not come into play, where even if I file something, I would be sent for arbitration. There would have been issues which could have been outside the scope of arbitration, and that, my lords, would have to be read only vis-a-vis the aspect of jurisdiction of courts.
Okay.
And, my lords, that is clarified by your lordships Balco. And if your lordships so want, my lords, I can just take out that relevant portion where they say that jurisdiction of courts and jurisdiction of arbitration are completely different things and they cannot be confused together. Now, this is at page 96. I'm sorry, it's page 605, para 96.
Is it here with us? No?
Balco.
2012.
It was referred to, my lords, in the earlier round of litigation. I'm sorry, we did not give a fresh. Well, this is 2012 9 SCC, page 553.
Yes.
If your lordships kindly have page 605, my lords, para 96. Lordships have it.
Yes.
Just 2 lines from the bottom, my lords. We are of the opinion that the subject matter of arbitration cannot be confused with subject matter of suit.
Yes.
The term subject matter in section 2(1)(e) is confined to part 1. It has a reference and connection with the process of dispute resolution. Its purpose is to identify the courts having supervisory control over the arbitration proceedings. Hence, it refers to a court which would essentially be a court of the seat of arbitration process. In our opinion, the provisions of section 2(1)(e) has to be construed keeping in view the provisions of in section 20 which give recognition to party autonomy. It goes on, my lords.
Yes.
Now, my lords, coming to having to deal with the judgments which my learned friend has placed before your lordships. This is the first judgment which has been placed before us, my lords, is Khushraj Bhatia. I am instructed, my lords, probably this is an appeal. But we'll obtain instructions, my lords, but probably this is an appeal before the Honorable Apex Court. Okay. My friend says, my lords, it is not an appeal. If your lordships have page 2, paragraph 5, my lords.
Where is the second for violation? Yes. Page
5.
Okay, yes.
Page 2, paragraph 5. Sorry. Page 2, paragraph 5.
Right, clause 48.
Well, clause 48 provided for determination of disputes which may arise from the lease deed, which reads as under. All or any dispute arising out of, touching upon, or in relation to the terms of the lease deed. So, my lords, what I submitted before your lordships, it is the all-encompassing arbitration clause.
Yes. So you distinguish it that way?
My lords.
Yes. Yes.
The other aspect of the matter is, my lords, here the courts were dealing with an application under section 11 of the Arbitration Act, not under section 34.
Okay.
That is established at page 15. The venue themselves. The main argument in respect to jurisdiction of this court to entertain a petition under section 11 of the so-and-so, it has been claimed that under so-and-so it has been provided that civil court at Gurgaon and the High Court at Chandigarh alone shall have jurisdiction. At paragraph 15, my lords.
Yes, yes.
And, my lords, at para 28. Having discussed the distinct concepts of seat and venue, it may be examined as to how these two concepts have been interpreted and applied in various situations. In so-and-so, 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 decided on so-and-so, the coordinate bench of this court. Similar question came up for interpretation. The parties have agreed for venue of arbitration to be New Delhi, but the other clause they had agreed that all actions and proceedings arising out or related of the contract shall lie in the courts of competent jurisdiction at Guwahati. I pause here, my lords. It is the admitted case of the petitioners that there was no venue or seat agreed insofar as arbitration is concerned. 58.2, my lords, I had distinguished it by reading 71, is only with regard to certain matters which would have been exclusive of 71, which would have come under 58.2.
Okay.
So, if it is exclusive of 71, my lords, there was no agreement per se between petitioners and respondents insofar as the jurisdiction of courts in Shillong are concerned. So, that entire argument goes that we have submitted and we have agreed to courts in Shillong, whether the word exclusive is there or not. Swastik Gas seals the matter. So, I will not even enter into that domain. Regarding the jurisdiction, my lords, would have been exclusive of arbitration.
Okay.
The court held that since the clauses of agreement expressly provided that the courts at Guwahati would have exclusive jurisdiction, it was a contrary indicator coming within the exception as held by the Supreme Court in DGS Soma. My humble submission is there is no contrary indication. My lords, and paragraph 31, which was read by my learned friend, it is quite evident that there is a contraindication in the registered agreement that while the venue of arbitration may be New Delhi, but the seat of arbitration shall be Gurgaon and the High Court at Chandigarh. In the circumstances, it has to be held that this court has no jurisdiction and it's the courts at Gurgaon, High Court of Chandigarh, which have the exclusive jurisdiction for entertaining the disputes arising out of the registered lease agreement. This is not the case here. Even on facts, it is distinguishable.
Yes. Yes, continue.
Well, it's the second judgment which my learned friend has placed is, well, it's Calcutta High Court.
Yes. Yes.
And Malaj, I again go back. Malaj, first your lordships, we would have paragraph 3 at page 10.
Rival submissions.
Malaj.
Yes.
The arbitration clause is reproduced here.
Yes.
Any question, dispute or difference that arises between the parties hereto in relation to concerning the rental schedule so-and-so, 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 Malaj, and assignment of any rights there under as to the rights, duties, liabilities of the parties or any of them either during continuance of this agreement or after termination hereof shall be referred to arbitration of a sole arbitrator. So again, my lords, all issues are within arbitration. The moment all issues are under arbitration, my lords, they cannot be any quarrel
any or every dispute. You're saying.
Yes.
Okay. Yeah.
So the moment we say any, my lords, then section 8 comes into play. Then of course, my lords, if there is a determination of a court, that would have some bearing. That would be a contrary indication. But once that there is a zone outside arbitration, my lords,
that will come in 58.
then it cannot be a contrary indication.
Okay.
And the same, my lords, this is again what persuades the court to pass this judgment, my lords, at page 19. I find myself in consonance with the above view in the circumstances where a place is designated merely as a venue and the courts of another place have been granted the exclusive jurisdiction. The latter is clearly contrary indicia. It can be inferred from a comprehensive reading of such clause that the venue is a convenient place of arbitration and not the seat. Then, my lords, at para 21, contractual interpretation necessitates taking into consideration all clauses and relevant factors to propound the proper intention between the parties. The rule of harmonious construction must be applied so that a panoramic meaning can be given to any agreement. This, my lords, would seal the matter in my favor.
Read it again.
Contractual interpretation necessitates taking into consideration all clauses and relevant factors to propound the proper intention between the parties.
That is what? What was the proper intention between
the proper
parties
intention
when
between
58.2 was introduced?
I'm sorry.
What was the intention of the parties, of the owner of the contract to enter that 58.2?
58.2, my lords,
that, yes.
my lords, which is why I again go back to what I had submitted before your lordships,
Yes.
and I'll, at the risk of repeating myself, I'll try to make myself a little more clear.
No, why not? Yes.
58, my lords, your lordships will see, if the intention of the parties was that everything goes into arbitration, and anything that arises out of that arbitration, the courts in Shillong would have jurisdiction, then, my lords, there was no reason to put 58 in front and 71, which is the arbitration clause, below. The moment I put 58 front, my lords, I am contemplating a situation.
You segmented other disputes from
segmented other disputes, which is why I'm saying, my lords, if we were to draw a Venn diagram, my lords, this is the arbitratable issues. These are issues which are outside the arbitrable issues. And to that extent, my lords, 58 would come into play and the jurisdiction would be Shillong.
So that means this case has a different footing altogether from all these cited cases.
Well, which is why I say the construction, and which is why, my lords, I read this and I'm grateful that this line came into my notice, that your lordships would have to take a harmonious view of what has been the agreement between the parties. 71 is very specific, that there are junior engineers, there are A, B, C, D. They may have a certain view. Chief engineer may not essentially subscribe to that view. They may take a view in favor of the contractor. Chief engineer may not take a view in favor of the contractor. Then he will pass an order. If he passes an order, my lords, against that, arbitration has to be invoked by the contractor. It is only under those limited circumstances that arbitration emanates. This wall is to be painted blue, but I paint it white. That is not an arbitrable issue.
Okay.
So therefore, my lords, all these judgments work on the premise of all disputes.
Inclusiveness of everything.
Circumnavigating, my lords, it is something that is very comprehensive. Once it is comprehensive, then of course, the jurisdictional court would have a bearing to the matter of decision. That would be then when you apply the Shashua principle, as your lordships, my lords, spent a considerable time hearing us on the Shashua principle, then your lordships would then have to go into Shashua principle. Then Shashua principle is said, okay, very well, you agreed to do your arbitration in place X. But you have agreed that the courts at a certain place Y, would have jurisdiction. So therefore, it is a directly contrary indication. There are two different, which are directly contrary to each other.
Okay.
So therefore, we cannot take a view that place A, where the arbitration is held, would be the seat of, well, it's the arbitration, and therefore B, where the courts are situate, that would be a relevant factor for the purposes of deciding thing. Here is a different situation.
Okay.
Well, the next line is also very important. Well, I'll just I'll read it. The rule of harmonious construction must be applied so that a panoramic meaning can be given to any agreement. Very interesting expression they've used. A panoramic meaning has to be given to the agreement.
Panoramic is a very dangerous word.
Panoramic, my lords, because your lordships will have a wide conspectus.
Yes.
Your lordships will examine every detail.
Now you're advocating that she is specific, with regard to interpretation. But panoramic means something else altogether.
No, panoramic, my lords, panoramic view of the agreement. Only when your lordships have a panoramic view of the agreement, then your lordships will identify specific issues which have to be dealt with.
Okay.
Which my lords then pointed out as 58.2 and 71.
Okay.
And why 58 would be where 58 is and why 71 is where 71 is. My lords, same as the case of Allahabad High Court, my lords, which your lordships would find at page 22, paragraph 2, my lords. 4 lines from the bottom. I'll not burden your lordships with reading the entire thing. Clause 17.1.2 provides for jurisdiction of the court for entertaining all the disputes between the parties.
Okay. I mean the keywords all.
All.
Yes.
So the moment we agree to all, my lords, and there is a clear indication that you've agreed to some other court somewhere, then I cannot say that the seat will decide or the venue will decide, my lords, where the arbitration is to be. That would be application of the Shashwa principle. And that is clarified at page 28, my lords, paragraph 19, which my learned friend had read. Applying the aforesaid law and facts of the present case, there appears to be a contra-indication in the agreement to the extent that the venue of arbitration is stipulated to be Lucknow, whereas the courts at Agra and Allahabad are given exclusive jurisdiction in case of any dispute arising out of compliance, non-compliance of the agreement. From the jurisdictional perspective, Lucknow is the only venue or location for conducting arbitral proceedings. The exclusive jurisdiction clause contained in the agreement constitutes significant contrary indicia as per Shashwa principle. And only the courts at Agra, Allahabad will have the jurisdiction to decide the disputes between the parties arising of the agreement in question.
Anything else?
Well, next is same page 30. Again, what my learned friend had read, my lords, paragraph 3, arbitration, and 1, 2, 3, 4. 4 lines from the bottom, my lords, your lordships, just after where it is in bold. It says, in all matters arising out of concerning the application form would be the arbitration.
So the keywords is all dispute.
All. So the moment all comes in, my lords, when there is a contrary indication, then I cannot take the plea that the venue would have been the seat and therefore jurisdiction will lie there.
Yes, okay.
That's all.
Yes.
There's bullet points already, my lords. The only thing I'll have to deal with this aspect, we can just add this paragraph.
You submit it.
Right.
Otherwise, anything else to say, Mr. General?
Few things.
How many minutes?
It takes some time, about half an hour. Either we can do it today or subject to.
We can do it tomorrow.
Tomorrow also.
Just give a reply tomorrow. Meantime, you can address and give the bullet point by tomorrow also. It's a list for further hearing tomorrow. Interesting in the sense that,
28.
Right.
First page. You can check. Was then 28? 28. None appears just after. Yes, 28 is there. Yes.
The conductor counsel has to check he's coming.
He's coming?
He's coming.
Where is he? Yes, Mr. Sheikh.
Lordship, here today 2 matters are taken together.
Any other urgent matters, we can continue at 2:15. We'll rise at 1:15, but 2:15 we can continue.
Then next week, Lordship.
Why? Where are you going?
I'm not going to the Lordship. Yes, today.
Yes?
Past one, Lordship.
Why your brain doesn't work anymore? Past one?
No, Lordship. Because my Lord.
No, we'll sit till 1:30, yes. You can finish.
After 1 week then, Lordship.
Yes, 1 week. Let's praise the matter between after 1 week. Yes.
It will take little time, Lordship.
Take little time.
29?
And will pleasure.
29?
All
Same connected, 20, 29. 30 years.
30?
Of that.
Yes. What remains in 30? MSD Cruz arguing the matter, correct?
Lordship, I'll be assisting.
Saying whom?
Conducting counsel, Lordship, senior counsel.
Mr. Paul?
Yes, Lordship.
Mr. Paul is exhausted, he's run outside, can't you see? Start, yes. What was the issue here remaining?
Lordship, the core issue would be the authority of the SEAM in collecting or levying any tax on the notified route.
Central government, who's there? With Dr. Mozika.
Under CM.
I'm here. 6 and 7 is here.
CM is?
Here.
Oh yes,
here.
of course, sorry. Where's Mr. Kanta? Kinta.
Yes, he's done.
For the state is concerned, Lordship, whether that road belongs to the CM or to the state, we have clarified by the affidavit, Lordship, that that is not a state road.
No, that PWD has clarified they're not maintaining that road. Okay, we'll have it after 1 week then. He's ready now. But where's Mr. Kinta? He doesn't come anymore. You avoids my court, I think. Yes.
He was arguing forcefully one criminal matter before Justice Masapiti. Maybe he got tired.
No. Mr. Kinta is not there. He's seeking some accommodation. He listed after 1 week, yes, as the senior arguing counsel. We have respondent number.
It's number 5. Yes, 5. We are 6 and 7.
6 and had to leave the court.
No.
Yes.
It's 5, R5 here, Lord.
5.
Mr. Councillors?
4 and 5, okay. Yes, next matter.
31?
Apply,
Where's the like?
My lord, I'm appearing on behalf of Sri Arguru. He's online, so I pray.
He's online?
I pray for.
Where is he? He's online or on legs?
Only.
Huh?
Online.
Online? Does that come online?
He's on ledge, Lordship, before
He's
the
on?
courtroom 4. On ledge before the courtroom 4.
Before the?
Courtroom 4. Oh, courtroom 4, yes, sir.
I heard online.
I pray for 1 week.
What is your name?
Rachna Guru.
The first time you appearing?
Yes.
Okay. You record her name. So for counsel praise the matter be adjourned to 1 week due to the absence of the arguing counsel. This lists after 1 week.
Much obliged.
33?
Big difference in on legs and online. Remember that.
Your Lordship, learned DSG is still on next before courtroom 3, Your Lordship. So if this matter.
But where are the other matters connected to this matter? They all listed to today.
34, 35.
All of them.
Your Lordship, one is listed in the order section. That is
Which one is
WPC
that?
112
Who's appearing in 112?
We are appearing.
Rejoinder is awaited, Your Lordship. It may
Item
be
number
taken
9,
up.
which was listed today with us.
No, but the rejoinder you filing when?
We had sought 2 weeks
2
time.
weeks time, Your Lordship.
Then we'd might as well hear them all together. What's the point? They all have some substance the same.
We'll file a rejoinder by next week, Manoj. I think by next week.
The list will matter for 1 week. We'll list that together.
Let it be listed in second week of September.
Oh, you're leaving the country again? You soon become expert. You'll have to take an OCI. Oh no, PIU. Oh, OCI. PIU, yes. Right. After 2 weeks. This is after 2 weeks. Together, we just give the number. Together with, just give the number to the.
PC number 430.
430. Next time we come, we'll finish it off.
I'm ready to deal.
I don't think they have. They have a. Anyway, we'll not.
You want to actually give
Give any observation.
Okay.
I rejoinder not necessary. We could want to see. It's all the same.
If your lordships, please
No,
hear the matter, we can hear the matter also. That rejoinder may not.
I can make my submission then.
Now.
He can. Yes, say hardly 2 points are there. What they have raised in their affidavit. Those I can just.
You can take out 215 then.
Okay, man.
215.
Okay.
36. 36.
Your Lordship, under instructions of the conducting counsel for the respondent, I seek some more time for this matter. Let the matter be taken after 3 weeks, Your Lordship.
P. Bhattacharjee.
Yes, Your Lordship.
There is a stay in our favor, my lord.
Yes, a request has been made on behalf of MS P. Bhattacharjee that present in the court today for some accommodation for 3 weeks adjournment stop. Today is on this matter of the 3 weeks. Interim orders. It's already.
Until further orders.
Second call, 23.
Mr. Ganguly is still not online, Malaz. We can have it after 3 weeks, Malaz. I'll inform him.
3 weeks?
Or 2 weeks.
2 weeks is the counsel respondent, Mr. Ganguly, is present or available online. This matter for 2 weeks. Yes. 215 then. 215. Because Dr. Mosika has to come here to arm himself also. He'll say, I'm not prepared. That's the only problem. No problem, You ready to the matter today, Dr. Mozika? You ready? Well, she's not
He's
here. She
always
insisted because he's just a visiting, senior counsel now.
Madam can start, my lord. I'll try to respond to if something is left, my lord.
You can respond. No. Only he wants to record the submissions.
May I please, Your Lordship? This is the Northeastern Center for Technology Application and Research, in short called NECTAR. They have given an advertisement on 10th July 2021, that is at Annexure 1, page 30, my lord.
Page 30.
Page 30. It is starting from page 30. This is NECTAR vacancy announcement 10 July for regular post in NECTAR. Then details have been given in the format. So these are the posts. Page 32 also vacancy announcement. All these posts were there. 16 posts. At page 33, my lord, at the bottom of that table, it is said that all the posts are proposed to be filled up on deputation, including short-term contract, absorption, failing which by direct recruitment basis. So, in response to this advertisement, the petitioner herein, he applied for that post, and a duly constituted screening committee shortlisted the candidates.
Which post he applied for?
He applied for the post of Chief Coordinator Technical.
Where is that?
Serial number 4.
Number 4. Chief Coordinator Technical.
Chief Coordinator Technical, that is at number 4.
Okay.
Now, duly constituted screening committee shortlisted the candidates, and at Annexure 3, page 59, my lord, on 10/12/2001, the shortlisted.
Sorry.
Page 59, my lord. And this post was, the advertisement was given in all the newspapers, which we have enclosed also.
Page 59.
Yeah, page 59 is the list of shortlisted candidates for this post. Annexure 3A, page 59.
Yes.
His name is also appearing at number 4. On the basis of recommendation of screening committee and approval of the competent authority. Approval of competent, the following candidates have been shortlisted for personal interview. Then at page 60, Annexure 3B, this is the selection committee which was duly constituted by the appropriate authority. Nomination of members for the selection committee which was duly constituted. Then the petitioner appeared for the personal interview and he was selected for the post. Now by Annexure 4 on 13 December 2021, offer of appointment was issued to him. That is page 62, my lord.
Yes. 13/12.
64 also the offer of.
1 second. 13/12.
13/12/2021.
Call for personal interview.
Yes.
Yes.
For the post of chief coordinator. And next page, Annexure 5, page 63. The result of the personal interview held for the post of chief coordinator is the result has been declared on 12th January 2022. At the time of when petitioner applied for this post, he was working in Meghalaya Basin Development in that organization. So an offer of appointment was issued to the petitioner by Annexure 6 on 19th January 2022, page 64. Offer of appointment to Sri Rakesh Kumar Sharma for the post of Chief Coordinator in Northeast Center for Technology Application and Reach, NECTAR, Shillong. And in the terms and conditions of the appointment letter, in clause number 9, it is also mentioned that services may be terminated by giving 3 months notice.
1 second. Number 9. Okay, clause 9.
One of the condition was there, the services may be terminated by giving 3 months notice by either side. The service, the appointee or the appointing authority.
Yes. An appointment order.
Yes. The appointment order was there, my lord. Next page, Annexure 7, 11 February 2022, appointment order and pay fixation. To join in this post, petitioner resigned from his earlier post. His resignation was also accepted on 20th January 2022. That is at Annexure 8, page 67, my lord.
Okay.
Where he has given his resignation that I would like to inform you that I will not be able to serve your organization as a technical specialist. So he has resigned from that post, which was duly accepted. Meghalaya, that page 68, next one, you know.
Yes.
The resignation of Rakesh Rama is hereby accepted. And he duly joined in this post. And page 69, his service book was also open in this post.
Annexure 10.
Yes, my lord. Then suddenly on 7th 10 2022
On
by this letter,
page 73.
Annexure 11, by letter dated 7/10/2022, petitioner is informed that his appointment has been cancelled.
You had worked for how long? For only from 11 to 7/10. That means 8 months.
Oh, yeah, almost 9 months. He joined on January.
It's impugn order. Right.
Yes, 1st February 22 he joined. 7 October. Almost
Yes.
9 months. By this letter, in terms of para 3 of service laws of Nectar, appointing authority for post carrying grade pay of 6,600 above is Governing Council Nectar. Your appointment letter for the post of Chief Coordinator carrying grade pay of 7,600 was issued by this office letter in anticipation of ex post facto approval of Governing Council of Nectar. Due to certain represent the matter, the Administrative Ministry disapproved a recruitment to Group A post carrying grade pay of 7,600, which consists of your recruitment as well. Accordingly, Governing Council has instructed to scrap the recruitment process and initiate afresh as early as possible. In view of the decision taken by the General Council Nectar, the advertisement for the post may be considered as null and void. Accordingly, your appointment to the post order number so and so is withdrawn with immediate effect, and your appointment to the post of Chief Coordinator may be treated as cancelled. This is the appointment. My lord,
They want to switch it to contractual. They wanted to change it.
No, not that. These were all regular posts. Now, in their affidavit, they have admitted.
No, the last line is further, it may be allowed
for the time being. I mean, after cancellation, they were offered that you continue as contractual and then it will go for re-advertisement. That is what they have given. Now, Your Lordship, in their affidavit, Nectar is a new establishment which was established here under Government of India. And initially 31 posts were sanctioned. But because their bylaws and all were not framed, so they could not recruit. That could not be done for 2 years. As a result, those sanctioned posts were deemed lapsed. But subsequently, again, 26 posts were revived. So for the 26 posts, this advertisement was. These are sanctioned regular posts. And what stand now they have taken, as per the rules of the Nectar, for the post of grade A post carrying salary of 6,600 and above, the appointing authority is the Governing Council. And for the other post, it is the Director General. In this case, the appointment letter was issued by the Director General. So that is one of the ground that they have taken.
Incompetent authority.
Yeah. But here, this was ex post facto approval was given by the Governing Council.
It's there.
Yes, that I will show. Now, If your lordship will come to Annexure 12.
Yes. Annexure 12.
This is the General Council meeting held on 14 October 21. Annexure 12 at page 74. Annexure 12 starts from page 74. The relevant page is at page 77 under item number 8 in that meeting of General Council, revival of sanction post and status of recruitment process. Here in the meeting.
One second. Item number 8.
Item number 8 at 77, page 77.
Revival sanction post.
Yes, revival of sanction post and status of recruitment process. General Council took note of the revival of the sanction post with satisfaction on the status of the progress of recruitment process. So recruitment process includes everything right from advertisement, screening and selection. So there is no complaint. It is with the approval of the, so far as recruitment process is concerned, there is no lapses or there is no fault on that. The General Council has approved and they have expressed their satisfaction with the progress of the recruitment process. That is noted. Now, in the 8th General Body meeting held on 18 April 22, that is Annexure 13, starts from page 81.
Annexure 13.
Annexure 13. This is very important, my lord. 8 General Council meeting. Here under item number 4, which is
Why is Governor Mizoram?
No, why, my lord?
Why is Governor Mizoram on top?
Here, members. He was that government of Mizoram chief secretary. He acted. He has, because the members of the governing council are the chief secretaries of different states, secretaries and or all the northeastern states. So that meeting he had circulated this. Now at page 83, my lord. First, I will see item number 1, confirmation of the minutes of the 4th meeting of the governing council. Okay, that is okay. Now here we'll go to item number 4. Under agenda item number 4, appearing at page 84. Status of recruitment process and approval of governing council. By then, already selection is completed, interview is held, appointment letter is issued. Chairperson requested, may I read your lordship, please? Chairperson requested to clarify the sub-paras under item number 4 meant solely for information and noting, approval of GC and the sub-paras pertaining to approval for amendments in RRs, upgradation, downgradation of post and or relaxation age. DG Nectar briefed the GC members about the nature of sub-paras under item number 4 of the agenda. Sub-para-wise proceedings under the agenda then progress as hereunder. Sub-para 4A. GC was apprised about the recruitment process relating to Group A post carrying grade pay of rupees 6,600 and above. There were 5 posts on this. One they continued, same way, same selection process, same advertisement. For one post, they have upheld, which was also a similar way done, but only for this 4 posts, they have cancelled. They said it is cancelled. The criteria mentioned in the recruitment rules and role of GC in terms of Rule 3.1 of Service Bylaws of Nectar for regularization of Group A post carrying grade pay of rupees 6,600 above was explained in general for seeking approval of GC. Chairperson asked DG Nectar to clarify whether recruitment rules of Nectar as approved by the appropriate authority have been followed in the matter. DG Nectar assured the chairperson and all the other GC members that recruitment rules have been scrupulously followed and also the procedure. Selection of candidates has been made by the selection committee, interview panel duly approved by the chairman Nectar in a transparent manner. Score sheet of marks awarded by the selection committee duly signed by each member of the committee is available for perusal and records. The scores of each candidate were displayed on the website of Nectar. Not a single representation from any of the candidates has been received in this regard. The offers of appointment were sent to the candidates in order to merit following the precedent adopted by Nectar in recruitments made earlier and approved by GC as well. Further, the status of recruitment has already been brought to the kind notice of GC members through circulation via this office letter number so-and-so dated 25/2/22 for approval for regularization of these appointments in terms of para 3(1) of service bylaws of NECTA and as advised by DST. Vide Under Secretary AI Division letter number 16 March 2022. Executive Council NECTA has already approved these recruitments during its meeting held on 21/2/22. It was also informed that approval of 5 GC members, that means from Chief Secretary Meghalaya, Manipur, Nagaland, Sikkim and Secretary NEC, has already been communicated through correspondence. As such, approval of remaining GC members was also sought for in terms of the provision contained under Rule 9 and 10 Part 3 of the General Bylaws of NECTA. All the General Council members endorsed their approval. So, post facto approval has been given to these appointments by the General Council. Chairperson desired to place approval of GC before Secretary DST being Chairman of NECTA. That is only after it is already been approved, Chairperson only desired to place it before the Secretary. That's all. So, this is where on the 8th meeting, the GC meeting held on 18 April 22, ex post facto approval has been given by the General Council and they are the appointing authority as per the rules. Now, subsequent to that, in the 9th General Council meeting.
So 7th they found okay, 8th they found okay.
Yes. So far what you have seen in the General Council meeting, they have approved all the entire recruitment procedure.
Can a General Council meeting review the early General Council decisions?
No.
Is it permissible?
Provided it is not passed. If once the minute is passed and confirmed, there is no scope of again reopening.
These are confirmed, correct?
Yes, that is what I am bringing, Malone. Now, on the next minutes of 9th General Meeting held on 18th August 22, Annex of 14, page 89. On the 9th meeting, and the very first item appearing at page 90. Item number 1. Confirmation of the minutes of the 8th meeting of the Governing Council. The minutes of the 8th meeting of the Governing Council were read, confirmed and adopted.
Yes.
Without any observation, without any reservation. So entire minutes of the 8th meeting of the GC were read, confirmed and adopted. So that is passed. Even item 2, action taken report on decision of 8th GC meeting, the action taken report was noted with satisfaction. After everything is over, all the agenda is over. At the end, at the closure of the meeting, they take up another item. Page 98. Item number 14.
98, not
page 98 on the reverse side.
Oh, yes. Okay.
Item number 14. Any other item with the permission of chair. So, my lord, this when in any meeting, when any other item comes, this will not include all the agenda items which already been decided earlier as per agenda. So definitely item number 1, where the minutes of the 8th meeting was confirmed and passed, that will not come under this agenda, any other item. So any other item with the permission.
Notice satisfaction
yes.
Meetings.
Now here they have said recruitment process update received from Ministry. General Council concurred a decision of Secretary DST on the scrapping of the 4 mentioned posts and directed to do the recruitment process afresh.
Well, discussed in early items, this one.
Nothing was discussed.
The decision of Secretary DST
Nothing.
Scrapping of, it was not discussed at all.
Not discussed.
Then concur the decision. Where's the decision? Is there some document showing the decision of this? Who's DST?
Director Science and Technology. Director Science and Technology. Now, here, Your Lordship, what is there? As per the rules, it is a General Council who is the appointing authority.
Correct.
And any decision, it is the majority of the members who say that is the decision of the General Council. I'll show the relevant portion of the rules also. So the chairman, DST, Secretary DST, who is the chairman, he do not enjoy any extra power or additional power or special power to give any further. Only if there is a tie or there is a contradiction or any voting is there, then he will have an extra vote for that.
Yes.
But otherwise, he do not enjoy any other power. Once the General Council, all the members of the General Council has approved and passed, he can just suggest, he's suggesting, but that has got no relevance, Your Honor.
What is the power of this DST then?
Director, but all the powers have been given to the Director General for the functioning, for everything, appointment. Only for the post of, he's the chairman of the General Council. He's the chairman of the General Council.
Right.
But
can he overrule and make decisions on his own unilaterally? Can he do it unilaterally?
He cannot do it. He do not enjoy. He's not given that power. He doesn't have the power.
Power preeminence over the other members. No,
it is not this fellow. It is the authority is the General Council.
No chairman's prerogative.
No prerogative. Only in case of tie has an extra.
No, but
here the question.
One thing you see.
Yes.
Why I'm asking this question? GC concurs his decision of Secretary DST. That is what. I thought maybe he has a different decision-making capability, which which maybe needs concurrence. So even if any other matters of which a decision they just seeks the approval of the General Council is given.
That is, there is no other discussions held here. Only that point is given.
The discussion won't be reflected here, but
yes.
We'll ask Dr. Mozika
But so far as then what happens to their action also has to be seen. Now what is the ground? On what basis? In their affidavit, this is what is the fact, my lord. This is what is the factual part. Now in their affidavit, they have annexed as annexure R4. Which is the basis on the basis of which they said this cancellation thing has started. Annexure R4, page 25. So they cannot go beyond this. What is here? They said there is a report of the Department of Science and report of the committee constituted to look into the recruitment process. Once a duly constituted committee, screening committee, selection committee.
One second.
Yes, my lord.
Report of the committee constituted to look into recruitment process and to.
Where is the scope of again?
An internal committee was constituted under the chairmanship of Shri so and so with so and so to look to recent recruitment process. Why? Why is this constituted? Why was this special internal committee?
Is there any scope of again once a duly?
Just let's get the basis. The base story correct. Now, after
they are giving the grounds below the committee.
Okay.
They are giving the grounds, and whether those grounds will be.
No. Why was this constituted? It said that it was irregular. The post had no authority to issue advertisements.
It is off the record. Their intention has to be seen because all the 4 candidates who were selected were from the Northeast. And from though wide publicity is given of the advertisement was widely published, nobody appeared, nobody applied. Those who applied, a duly considered screening committee has screened the applications. Duly considered selection committee. None of the candidates who applied in the screening who did not qualify in the screening committee, nobody challenged that it was wrongly done or this. Even after the selection committee was held, interview was held, there was no complaint from any quarter. No candidate who appeared for the interview had challenged anything. After they have worked for almost 1 year, almost 9 months, then suddenly this thing has come. So what does it say? Now they are saying an internal committee was constituted under the chairmanship of so and so with so and so members as members to look into the recent recruitment process in Nectar for the following post. These 4 posts. After going through the facts and documents made available, the committee makes the following observation. Now here I'll just pause, Your Lordship. It is the same screening committee and the selection committee who were approved, had also done the selection for all the other posts, including another grade A post. That one has been, by the same ex post facto approval, that post has been also given. But that has been retained, that they have not scrapped. Only these 4 posts they have given. In terms of provision as available in recruitment rules to the post, the method of recruitment was by promotion, failing which by deputation, including short-term contract, absorption, failing which by direct recruitment, instead of first making sincere effort for filling up the post on deputation basis, the vacancies were filled by direct recruitment mode. So the ground they are taking, it should have been first, they should have, as per recruitment rule, they should have. But the advertisement was That is what they have tried. This is this observation. This has been complied. In the advertisement itself, your lordship will see. In the same advertisement, they have clearly written that it will be posts are proposed to be filled up on deputation, including short-term contract, and failing which by direct recruitment. So even they invited applications.
One thing is that not enough effort was taken to get people on deputation.
No, but the same advertisement, even effort has been made for deputation. Now, when a regular post is advertised, if they say that they will uptake on deputation and organization, people who are interested to apply on deputation, they will apply.
Yes.
People who are interested,
nobody
applied for deputation, so effort has been made. All those candidates who applied, they all applied for a regular.
You see,
but it is not that the effort was not made.
Para 2, small Roman 2, what you said about that?
This is, firstly, this main point which they have issued, they said no effort, but the advertisement.
Number 2.
Yes, number 2 said rejection of applications received for deputation on grounds of NOC, vigilance clearance, non-availability of APS, etc. does not hold justified as no efforts were made to get the same from departments, organizations of the candidates.
For deputation.
But the duly considered screening committee has screened for that which was not challenged.
What he's saying is that there was selection process regular.
Yes, but the effort was made to even for deputation. So maybe there was applications were not during screening, applications were not found eligible.
Okay.
There was some lacuna, but then the first observation that this has been made, that effort they have made. The screening committee has also not recorded any observation reason for considering the candidates on direct recruitment basis without exhausting the other available mode of deputation in accordance with the prescribed recruitment rules. Issuing an offer of appointment, this is only on that
part. For the screening committee, not you.
Issuing of the offer of appointment and later candidates assuming charge of the post without approval of the competent authority, that is the governing council, is a serious lapse on the part of the institute. This is a major procedural lapse which cannot be ignored. Rather, this committee is of the opinion the responsibility must be fixed as the appointment made for Group A post, that too for level 2 and above. It is also observed that one of the members screening committee is also one of the candidates who has applied for a post. This is for administrative post. I have not. Nectar deviates the process of issuing appointment orders without approval of competent authority. Now, only basically the internal committee which they have appointed, they have raised 2 points that they should have first made an effort to appoint through deputation or this, and after that failing which by direct recruitment, not enough effort has not been made. So, but from here it appears that people did apply for on deputation, but the applications or due to lack of certain other documents, they on the screening committee did not pass through the screening committee. But it is not that key. Nectar did not try to make an effort. They also call applications to fill up on deputation first, and it was very clearly written that first it will be on deputation. If there were suitable candidates to be engaged as on deputation, then maybe they would have gone for that.
Okay.
Complying all the requirements, if fulfilling all the requirements.
What are your final submissions?
Now,
you're going to authorities.
Now, out of 5 grade A posts, if it is the same thing will be applicable to all, but why for number 1 post number 1, which carries, it is above 6,600, so that is carrying a pay scale of say 7,000, 10,000 something, senior advisor technical. His post has not been touched. They have particularly touched his post. Also, same ex post facto approval has been given. And that has remained. That has not been done. So if this is a fault for these 4 posts, it will be a fault for the other posts. So that itself shows that it is not a bona fide act on the part of the authorities to cancel. And once...
Where the name of that person you said, the other one was not been touched?
He's recruited... we have also enclosed his appointment letter with everything.
In the petition?
Yes. With our rejoinder we have given. Dr. Colin Z. Rentheli, on our advisor technical, for the post of advisor technical, and annexure 1 page 12 with our rejoinder affidavit. His appointment letter was also issued by Director General.
One second.
The last page of our rejoinder, my lord. But that has not been touched. So why this treatment?
Yes.
So it is wholly as an afterthought, and there is no scope of reopening. And besides that, Your Lordship, as
authorities.
Pardon, my Lord.
Show me the law.
I mean, we don't need any other supporting decisions also. The factual part itself is strong, my Lord.
Okay, fine.
Here, my Lord,
Show me the law, take the order.
Yes.
So simple as that.
My Lord, even in
Yes.
minutes of the 8th meeting,
No, that we've seen.
which has confirmed.
That we've seen.
So whether there is any scope again to reopen once which has been again reviewed, once which has been confirmed and already made final. And the petitioner who has already joined in that service, he had resigned from his earlier post. He has acquired a right over this post.
What about the aspect of being provisional, probational?
Oh, and that also, my Lord, here.
Any offer or letter says probation? No.
And only thing in the terms and conditions it was given, 3 months notice will be given. They were not even, that also was not compliant.
No, forget about that.
So that was
there's
also
no
not
question
compliant.
of being in probation, correct? There's no question of them being probation that they can be.
In their rules, in their service rule, it says the appointment will be on, they will be on probation for a certain time, but after even during probation, if they are to be removed, notice has to be given. That also they have not complied.
Yeah, Dr.
I'll just, yes, let me submit. I'll just take out the relevant portion of the service rules where it is about the probation part, my Lord.
Yes.
So it is wholly, totally, in my humble submission, if there is anything done by the screening committee, the candidates should not suffer for that matter.
Of course.
And there should not be a discriminatory action, treatment, if for one, and if the advertisement goes not only this, for the same advertisement for all the 26 posts. Where it was there?
It's not a case of the steering committee appointing authority not being a competent authority to appoint. Is that the case, right? It's not a case like that.
No.
Like suppose if for a certain grade pay and then like inadvertently they have been recruited directly and then it comes out later that they're incompetent authority to appoint.
No, here as per their service rules, they said for grade A post, the appointing authority is the General Governing Council. And below grade A post, all the posts, the appointing authority is the...
You're grade A.
Director General. We are under grade A, higher level.
Then grade A, that means that the
General Council is the appointing authority.
They appointed you.
No, in our case, the appointment letter was issued by the Director General.
But it has...
with the thinking, ex post facto approval has been taken.
So General Council is to give the appointment, who will sign appointment letter?
Chairman of the General Council. If it is General Council, and Chairman will sign. But there has been a precedent, and even in the meeting also it has been recorded that as per precedent followed earlier also, and this ex post facto approval has been given. In support of that, we can give some rulings, but in support of that, I will give the ex post facto approval is given, and that is legal and that is accepted here. And here also, this ex post facto approval has been given by all the members, all the General Council members. So, act which has been not done has been, it is only for a matter of regularization.
All the cases are similar.
Similar. All the 4 cases. And even the person for number 1 post, his appointment letter was also issued by the Director General. He is also, it should have been by the General Council, and his appointment has also been approved by the same meeting in the 8th General Council meeting. Ex post facto approval has been given, but by that it has been regular. This is a regular practice in any other government organizations also, department also. The ex post facto approval has been given in many decisions and even appointment. That is not a serious lapse. And then in this internal committee, we don't understand what was the scope of initiating an internal committee after almost 1 year, after candidates have joined. If there were serious lapses,
that's for
they should not have.
That's for response to show that
they should not have regularized.
It's so irregular that it cannot withstand. That had to be recalled.
My Lord, the problem in this present case, my Lord, started from the fact that, my Lord, The appointment letters were issued because the rules say, my lord, the governing council will be the appointing authority in respect of these employees, my lord.
Pointed out something regarding this.
Yes.
My lord, in this case, the appointment letter was issued on 19 January 22, my lord.
Yes.
So for appointment. And final appointment was issued on 11/2/22, my lord.
Yes.
This one day for probation. I pointed out.
Matter was considered by the governing council, my lord, in its meeting of 18th April 22, my lord.
This is in which one? With other copy. Just mark this one. Page.
A submission has been made and there is a ex post facto approval, my lord. In my humble submission, there is no ex post facto approval. Here on that day, what happened, my lord? If Lordship kindly turns to page 82 of the writ petition, my lord.
Yes.
Some significance of this document, my lord.
Page 82.
Page 82, my lord. But this meeting was chaired by Dr. Renu Sharma, IAS Chief Secretary, Government of Mizoram, my lord. Otherwise, the chairman of Nectar, my lord, is the Secretary, Department of Science and Technology, Ministry, my lord. On that day, because he was not available, my lord, the senior most member, C being the senior most member, and this lordship will also can see page 88, my lord. See signs as member, governing council, presiding chairperson. Page 88.
Where? 88.
Page 88, my lord.
Member GT. Member GC.
Member GC and presiding chairperson.
Okay.
For that particular day, my lord. And what was the resolution, my lord? I'll just point out the resolution at page 85, my lord. Just at the bottom, my lord, sub-para 4B, just one paragraph before that, my lord. All the GC members endorse their approval. Chairperson means the temporary ad hoc chairperson for that particular day desired to place approval of GC before Secretary DST being Chairman Nectar. He wanted that this should be placed before the actual chairman, my lord, who is not available on that particular day. So, my lord, in the next meeting, in the meantime, because he is the Secretary, Department of Science and Technology, which is Administrative Ministry also, my lord. So, Ministry constituted an inquiry. We have stated in our affidavit, my lord. And the report of the inquiry, my lord, says, my lord, the irregularities in the entire process, my lord.
What is the
I'll just once again refer to those few points in this, my lord, which are relevant, my lord. In terms of provisions as available from clause 1, my lord, I'll just read once again.
Where did he?
Page 25 of my counter affidavit.
25?
Page 25 of my counter affidavit.
What that?
That report, my lord.
Annexure R.
R4. Annexure 4.
Voice.
It says, my lord, after going through the facts, para 2, after the members, documents made available, the committee makes the following observations. In terms of the provisions as available in the recruitment rules of the post, the method of recruitment was by promotion, failing which by deputation, including short-term contract, absorption, failing which by direct recruitment. Instead of first making sincere effort for filling up the post on deputation basis. The vacancies were filled up by direct recruitment mode. Rejection of applications received for deputation on grounds of NOC, vigilance clearance, non-availability of APARs, etc. does not hold justification, as no efforts were made to get the same from department organizations of the candidates. The screening committee has also not recorded any observation reasons for considering the candidates on direct recruitment basis without exhausting the other available mode of deputation in accordance with the prescribed recruitment rules for the respective post. Issuing of offer of appointment and letting the candidate assume charge of the post without the approval of the competent authority, that is governing council, is a serious lapse on the part of the institute. This is a major procedural lapse which cannot be ignored. Rather, this committee is of the opinion that responsibility must be fixed, as the appointments made were for Group A post, that too of level 11 and above. It is also observed that one of the members of the screening committee, Sri Simon Fukan, Associate Nectar, is also one of the candidates who has applied for the post of Senior Administrative Officer, which evidently tantamount to conflict of interest. Now, my lord, this gentleman, Simon Fukan, is one of the petitioners, my lord. Who? Mr. Simon Fukan. He was a member of screening committee also. He was himself a candidate, my lord.
Yes.
Then Nectar deviates the process of issuing appointment orders without approval of the competent authority and on ascertaining reasons behind it. Nectar justifies and rather tries to influence that scrapping of the proposal will lead to litigation. This also corroborates that recruitment process is not transparent. The whole issue seems to be orchestrated with the ulterior motive of vitiating the recruitment process and select those only who are presently working on contract with Nectar.
How can they come to this finding?
My lord, if you'll also sees the name of the DG, my lord, the Director General, and of the 4 candidates appointed, my lord.
Same names.
That cannot be done. Cannot be.
And all 4 are aware.
Who's this person? He said the director.
Director General is Arun Kumar Sharma, my lord.
And his petitioners? Rakesh Kumar Sharma.
I also get confused, my lord, with the names. This is also Sam Kumar Sharma, my lord, the petitioner here.
Rakesh Sharma.
This is Rakesh Sharma. One is Simon Fukan. One is Simanta Das.
So what's the connection between Sharma and Fukan?
No connection.
My lord, connection in the sense that because they are already serving on contemptual basis, my lord, in the same establishment. No sincere effort was ever made, my lord, to have a transparent and fair and competitive selection process, my lord.
You mean to say the selection process according to you is vitiated?
Vitiated, my lord.
Then where have you sent an affidavit? That then leaving aside even that is, not that you setting up the ground, that's not, it cannot be a regular appointment or cannot be to direct recruitment. Then where is that material to show that you feel is already vitiated and that there are materials that to support your stand with regard to vitiation of the process.
This report itself is a material, my lord, in my humble submission. And my lord, the GC...
Whatever it is, Dr. Mozika, they have visited civil consequences. They have acquired rights. See, by virtue of you selecting them, you've cloaked them with certain rights. So you take away those things, then has to be on a very well-founded grounds. Not on notice, not anything. Did you even give them a letter to them prior to the...
My lord, in fact, their appointment itself says, my lord, that it can be terminated by giving 3 months notice, my lord. So in my embassy, at the most, the maximum relief they are entitled to is 3 months notice, my lord. And there will be fresh advertisement, they are free to apply, my lord.
My lord, first of all, my lord.
So why do you go to the new exercise to get more people? Are they unfit?
Maybe to get better people, my lord.
So, there is no complaint in this last 9 months that they have been working. There is no complaint that their performance is poor. They have not been doing properly. My lord, plus the service rules
that has been made. I can just complete one more point. My lord, the 5th candidate is from a different advertisement, from a different recruitment process. His interview itself, my lord, was conducted on 15th of March 23, my lord. The order itself says, my lord.
Selection.
It's from different recruitment process.
No, same advertisement, same screening committee, but selection committee is different for different posts.
My lord, page 12, the appointment letter which they were next, my lord, it itself says in pursuance of the personal interview held dated 15th March 2023 for the post of so and so, and on the basis of the grade awarded by the interview panel, the competent authority is pleased to appoint him so and so. And his case was duly approved by the governing council, which was chaired by the Secretary DS, Department of Science and Technology. So that parity is unfounded, my lord, with the fifth person. But as far as the
you answered that in your affidavit.
No. This has come by way of rejoinder, but this is evident from the letter itself, my lord.
The letter is issued by Director General.
This itself says, my lord.
This is also issued by Director General.
Interview held on 15th.
Affidavit.
Yes, the letter.
Wait.
The letter itself is signed by Director General. Obviously, posts are different, so selection committee is different. Selection panel. Different panels have taken this interview because posts are different.
This is to Collins Rentley.
Yes, but this letter is also issued by Director General. His appointment. Subsequently, now they are making up. That's a different matter. But his initial letter, which you have got, and it is before, they have not produced any other letter also in the affidavit. Now, and first of all, my lord, in their recruitment rules, like some other departments in their recruitment rules.
She hasn't argued for a long time, no? That's why she's getting very inspired, to argue. If you argued every day, she'll be tired. Yes.
My lord, so the parity with fifth is unsubstantiated, my lord. My lord, the appointment orders, what I saw the other day, my lord, is the honourable judge's appointment order is signed by Joint Secretary or something, my lord. That doesn't mean the Joint Secretary is the appointing authority. Well, this is simply communication of the appointment, my lord. So, my lord, in these facts, my lord, the condition of appointment, my lord, at page 65, my lord. It says, my lord, his service may be terminated by giving 3 months' notice by either side, that is, the appointee or the appointee.
I'm afraid, Musika, the way it's been gone about is not. It's very.
But the problem, what happened here, the director.
If you see the appointments are regular, even the cessation of employment also, the way it's gone about, it's like it's what do you call it? No process at all.
No process. That I admit to that. Even while appointing, the process was not followed correctly.
And even in the revoking that also,
that also is not followed correctly.
Service bylaws.
My lord, what is happening, my lord, at the grassroots level, my lord, also these things are happening. And from the ministry level, we are trying to rectify it.
No.
Even then.
This is in general bylaws, no?
My lord, all four who were existing employees of, it was basically a regularization exercise, my lord, lordship will see.
No, not that. My this present petitioner was working in basin development. I have shown he has resigned from.
He was not working, Doctor.
He was initially prepared, but he was working in.
Yes, he was not.
Basin development.
He resigned from.
Basin
11th of he resigned from basin and came there. Person loses a good post also. What happened to him? He'll be left destitute.
He can go back, my lord, to
basin.
It's that.
Job very hard to come by. The moment he must have left from there, must be 20 people must be lining up outside the door.
And he has lost other opportunities to apply in any other post in these last 9 months. Now it is more than 2 years.
There's another case also in Mizoram. What matter was that?
The Nilit.
Yeah, that also that's been disposed of. That's not before my bench anymore.
We filed no appeal.
Oh, it was disposed by his bench.
To the court, okay.
Oh.
General bylaw.
That was likely on.
What happened to appeal?
Not yet.
Not yet disposal.
Take out this page, this particular.
Around the similar kind of case.
So while appointing, because what is happening, my lord?
You get the judgment. What's that? What is the name of that case?
And this one.
I also forgotten. I thought that it's still pending.
Have another copy. Well, regarding this, yeah, finished. This point, what my learned friend has raised, in their own general bylaws of Nectar, bylaw 16 says, every meeting of the Executive Council shall be presided over by the chairman and in his absence by a member nominated by him for the purpose. So the power is given, even though he was not there. That has been given.
See, that is not really important because the fact remains that there were two meetings whereby the process and the procedure adopted has been endorsed by the General Council.
Not finally endorsed, my lord.
Whatever it is, endorsement is endorsement.
My lord, endorsement in the sense it should be placed before the chairman.
Not necessary. My lord, I may read out this.
After 2 rounds.
My lord, even the rules also providing in their rules and regulations of Nectar.
My lord,
here rule 7.
Second time again the General Council, all the members again concur with the decision of.
I think they like what they call it, those stool
that
pigeons,
is an afterthought with some malafide intention. Now they've taken.
And the thing is that the way of has come another item. That is such an important. You approve the resolutions made earlier of the other General Council. Then in the other items, you concur the decision of the chairman to.
My lord, in my submission, my lord, in the earlier meeting, the conclusion of that was inconclusive, my lord. That was not a final approval in that way, my lord.
On what basis?
When you say the third meeting is conclusive?
Third meeting is conclusive, my lord.
Then why did you approve the resolution of the? Where's the third meeting? That is at page
98. Page 14, the 9th one.
Annexure 14.
Annexure 14, page 89.
See, the Winter 7 meeting were confirmed, adopted. This is what meeting? 82. 9 meetings, sorry. And that's page 9 meeting, page 89.
89 it starts.
Okay. See, item number 1, confirmation of minutes of 8 meeting. The minutes of 8 meeting of the GC were read, confirmed and adopted. So
it is conclusive. He is admitting now.
That's what I am submitting, my lord. What is the conclusion of the 8th GC, my lord?
8th GC meeting has approved.
8th GC only says, my lord, chairperson desired to place approval of GC before Secretary DST being chairman of Nectar.
For what?
That is only a desire, my lord. Before that line, the previous line says all the General Council members.
For the final vote.
No, not for the final vote. Where is this scope?
Why is that not come as an item? That shows that even there was a slanted agenda that will bring it inserted in the other.
And my lord,
item before decisions of last FCEC meeting approval, whatever it is, it's taken up very in a regular manner. Even regular training of what is all this. Even item number 6, implementing honey mission, whatever.
Well, because, my lord, there are both the processes were vitiated, my lord, the appointment as well as cancellation, my lord. My lord,
appointment is not vitiated, my
lord. What does the court do?
Appointment is not vitiated, my lord.
Some middle path, my lord, somewhere that.
Appointment is not, my lord, even in their service rules and regulations of Nectar, in clause 7
it is come to a finding also, Dr. Mosika, that the appointment is irregular. It's by a due selection process.
But approval is not there, my lord. GC approval, which is the most important part of the recruitment process, my lord, that is not there.
Ex post facto approval is there, my lord, and that is a regular thing which is regularly practiced, and that cannot.
Recruitment, there cannot be ex post facto approval.
My lord, here it says any business. I may be allowed to read this. Any business which it may be necessary for the governing council to perform may be performed by a resolution in writing circulated to all its members by electronic and postal means, and any such resolution so circulated and approved by the majority of the members signing shall be as effectual and binding as if such a resolution has been passed at the meeting of the governing council, provided that at least 5 members of the governing council have recorded their approval to the resolution. So as per that, so quorum is even with 5 general members.
What are we reading from?
This is from the rules and regulations of Nectar, short title. It is very clearly mentioned. So
You see,
even
I
if
give a copy, then see, the thing is
I've
that
given.
I'm not a mind reader.
Yes, sir.
Where reading? Which part?
That is number 7.
What is this?
And
This is bylaws.
I don't have a copy of that. No?
Okay, we'll continue some other day. At least you heard MSPDB versus Barua for the petitioner. Stop. You have no other submissions to make. No? That's it.
Yes.
Yes,
And my submission, my lord, there is no scope after once it is already passed. Then
I'm very unhappy the way
there is no scope for.
They cannot, you, especially government organizations, should be a model employer, whatever it is, and everything should be said beforehand. What kind of recruitment are you going to do?
Well, what is happening? These autonomous institutions, they are given some leeway, my lord, and they have their own directives.
And sometimes there's no check or balance in their way.
We check it or control it when it comes for approval to us, my lord.
When it's too late. When the horse has run from the stable, then
here what has happened, my lord? If this has come to us, if appointment was not done and this was come to appointment already issued.
So it becomes fait accompli.
No, approval of central government for the post is not necessary. They have approved the post. Appointment again doesn't go to the government for approval. I don't know why the government again appointment doesn't go that government approval is.
There must have been some internal complaint.
Secretary
DST. There must have been some.
As a chairman, he
not given enough opportunity to apply. What happens like this? Anyway.
Secretary DST happens to be the chairman, but that doesn't mean that the appointment, once it is approved, whether ex post facto or approved, it is not required to go to the central government for approval.
Your lordships have fixed it on another day, which I can probably.
Yes, this is the court better. Only on those aspects, like is irregular. If you see you're using irregular appointment, it's irregular dismissal. I mean, like revocation also. These whatever can't sustain the action taken by you.
The interesting part as well is that committee also says fixed responsibility, take action.
On whom?
On whoever has done it.
That's correct. That means there's been some.
Fixed responsibility, take action. So they would also have to demonstrate that they've taken action against somebody.
The matters before the court, my lord.
That is not before the court.
Once we succeed here, we will do that.
What they very conveniently do as well as the people who are appointed, they are out. Post re-advertised. Whoever has done it, so-called anomaly, if it has been done, there has to be some heads rolling.
Well, out of 4 cases,
demonstrate that some heads have rolled.
Out of 4 cases, my lord, one is Simon Fukani, lords you've seen. He's a member of screening committee as well as
screening committee, because screening committee has to be from the department.
Screening committee's role is
he's also a candidate
of who are the applicants.
Check
position and place it before a
yes.
Oh, he screened himself, you mean?
Then there were other members also in the screening committee.
No,
if he did not qualify, if he is not eligible, if he is not having the required qualification, yes, screening committee, the office people will only do the screening. They cannot hire somebody from outside.
It's like that, or in jest, when we see in the airport, when we have the CIFSF personnel scanning us. So before he starts scanning us, he also scans himself.
Yes.
It's a common sight.
The machine is working on
and sometimes when they're not sure, they get touching on their own body to see that it's.
That the machine is working or not.
I'll address it.
When after 1 week, the list for Hertz also, who has concluded her submissions, has other connected matters are yet to be heard.
It will be listed along with that, those matters also. If I need to give any citation, I'll give.
He might just make an appearance. Well, you're not practicing anymore now.
I am.
Where?
Everywhere. Omnipresent.
Yes.
Obliged, man. Deeply obliged.
Lordships will have it after a week.
1 week, it'll come the list. After 1 week, you'll get advanced list, on which day of the week it'll come. Because court master, she's the one inside the board, because I can't fix dates. Sometimes they get clogged up in one day, so they leave it. We leave it to.
Obliged.
Obliged.